Oh, pardon to mention, my lord, I have filed an IA for production of a letter granting prior approval from the BO Khurda, sorry, Begunia. This was twice. This is a matter of 2017, my lord. Against the order of tribunal, 22/6/2017. So now, in the meanwhile, the petitioner has retired. This
What is the urgency you are making mention?
I have twice mentioned, my lord, because the letter has to come from, if your lordship will pass an order for date, this IA will be allowed, and the letter will come from the DO Khurda, my lord. Chalo.
Item, what's that? Please, on the list.
The press admission.
Pardon to mention, my lord, the petitioner is convicted. One IA is filed for bail. Both are equivalent cases. Obliged.
Yes, item 30 on your lordship's board is the matter which I wanted to be heard because despite a sales certificate having been issued in my favor in 2023, the other side is Mr. B.N. Udgata. He was here day before yesterday when I mentioned. He has filed an affidavit on that date also. But he's aware that the matter is going to be mentioned today.
So ask him after this press admission matter, we can take up.
I'll inform him. I'll inform.
Yes, I may be pardoned. Item 23 of your lordship's list on the second half, I have filed an IA today. Let it come on. Item 23, I filed the IA today. It's numbered as 3421. May I pray that it may be tagged with the
What
file?
is that IA?
That is an IA for extension, my lords.
Today it is expiring.
Yes, my lord. The Supreme Court has given us an interim order till today, so therefore I have prayed.
So why willing to extend if the Supreme Court has granted?
Well, the Supreme Court has directed that the IA to be taken up, so that therefore I have filed an IA.
File yes next week.
Grateful. I'm serving a copy of the IA to the state also.
Call the matters.
Supplementary daily. First up, item 1.
Please. My lord, in this case, my lord has directed the last official to file the consolidated cost title and file the requisites after that within 2 days. My lord, I have already filed the consolidated cost title within 2 days, but I have not filed the requisite. Why are you doing? There is a stay operating.
We are.
We will vacate it.
Vacate and
My
dismiss.
lord, on the course of the day, I'll file
This
today.
itself.
Take it. See, this is a matter demanded from the Supreme Court, and you last week only my lord has directed.
You deposit 50,000 cost in the High Court bar.
Sorry, my lord, I'll file it today itself.
No.
This is my lord, last
deposit the cost, otherwise
this is a remand matter. And a specific direction there is from the Supreme Court. Yes, and you can't take because status quo is operating.
You have already taken
Today
that.
I'll file all the requisites.
No.
Last chance.
File that. File 20,000 deposit and then we'll accept.
Sorry.
We'll dismiss.
My lord,
It is subject to the.
my lord, last chance.
No.
My lord,
The.
my lord, last chance, my lord. Today I'll file the requisite.
The learning. What is your good name?
My lord, Somyaranjan Paikrai.
Mr. Somyaranjan
Paikrai.
Paikrai, Land Council appearing for the appellant.
My lord, last
submitted that the consolidated copy of the cost title of the appeal memo has already been filed. When you filed?
3rd December.
On 3rd December 2025. But the requisites for issuance of notice to the newly substituted legal heirs of respondents number 5, 6, and 7 by Speedfood has not been filed. Stop. Needless to say that on 18/8/2025, when this matter was listed for the first time after disposal of the civil appeal number 8073 of 2024, wherein the Honorable Supreme Court remanded the matter for fresh adjudication,
Six weeks time was granted.
We as per the order dated 29/7/2024 of the Honorable Supreme Court, wherein a phrase notice was directed to be issued to the respondent. We directed the registry to issue notice to the respondents number 5, 6, and 7 by 28/2024, fixing the date of appearance on 1/9/2025, and the notice to be served on the respondents number 5, 6, and 7 through inspector in charge of police station, and the compliance report to be filed on the next date. We also asked the Land Council for the state to pass necessary instruction to the inspector in charge of both police station in that respect. As per the order dated 29/7/2024 of the Honorable Supreme Court, passed in Civil Appeal number 8073 of 2024, we directed the parties to maintain status quo till the next date.
6 weeks time was granted for this for them. 6 weeks time was granted.
Since in the aforesaid order, 6 weeks.
6 weeks time.
In the aforesaid order,
Last but one.
last but one.
6 weeks time.
The Honorable Supreme Court has observed that the subject controversy is to be decided by this court within 6 weeks. The matter was then listed on 8/9/2025. And on that day, the Land and State Council took time to produce the compliance report regarding service of notice on respondents number 5, 6, and 7. The matter was then taken up on 24/9/2025. And again, the matter was adjourned on the request of the Land Council for the state to produce the compliance report regarding service of notice on respondent number 5, 6, and 7. And the Land Council for the appellant was also asked to take necessary steps regarding filing of the consolidated cost title of the appeal memo, incorporating the substituted appellant number 1. Then the matter was listed on 13/10/2025. Again, the Land Council for the appellants took time to file the consolidated appeal memo. And the Land Council for the state took time to file the compliance report regarding service of notice on respondents number 5, 6, and 7. On 29/10/2025, when the matter was next taken up, the Learning Council for the state, on instruction from IAC Go Police Station, submitted that the respondent number 5, 6, and 7 are dead, and it took time to file an affidavit to that effect. Then the matter was listed on 10/11/2025, and the Land Council for the state filed the compliance affidavit of the IAC Go Police Station, wherein it is mentioned that respondent number 5, Ramar Borset, respondent number 6, Maheshwar Naik, and respondent number 7, Prabhakar Naik are dead. The copy of the affidavit was served on the Land Council for the appellant, who took time to file, take appropriate steps in the matter. And the status quo order, which was operating as per the direction of the Honorable Supreme Court, was also keeping in view the status quo of operating. So the Learning Council for the appellants was asked to bring the legal heirs of the deceased respondents number 5 to 7 on record. Then the matter was listed on 1/12/2025, and on that day, the interim application filed by the Land Council for the appellants for substitutions of the legal heirs of the deceased respondents number 5 to 7 was taken up, and the same was allowed, and the legal heirs were permitted to be substituted in place of the respondents number 5, 6, and 7. Accordingly, the Land Council for the appellants was asked to file the consolidated copy of the cause title of the appeal memo, and also to take steps for issuance of notice to the newly substituted legal heirs of the respondents number 5, 6, and 7 by speed post, which was directed to be filed within 2 days. And the interim order passed earlier was directed to continue. Today, the Land Council for the appellants submitted that so far as the filing of consolidated copy of the cause title of the appeal memo is concerned, that has been complied with. But so far as the filing of requisites for issuance of notice to the newly substituted legal heirs have not been taken. within the stipulated period of 2 days as per the order dated 1/12/2025. However, he submits that the requisites can be filed during course of the day. It seems that after passing of the status quo order by the Honorable Supreme Court in Civil Appeal number 8073 of 2024, which was disposed of on 29/7/2024, and wherein a specific order was passed by the Supreme Court order to decide the matter within 6 weeks. The Land Council for the appellants is adopting delay-daring tactics, which is not initiated by this court.
About 8 adjournments.
And the case has suffered 8 adjournments. And though it was the duty of the Land Council for the appellants to bring the legal heirs of the deceased respondents number 5 to 7, but only after the same was apprised to this court by the IIC of so-and-so police station, the application was filed, but no steps have been taken as yet for service of the notice on the respondents number 5027. This is respondent number LRs of the this is respondents number 527. In view of the fact that the service of notice on the LRs of the 5 to 7 so and so is very much necessary for adjudication of the case on merit, we allow the prayer of the Land Council for the appellant regarding filing of the requisites during course of the day, subject to deposit of rupees 20,000 in the High Court Advocate Welfare Fund. If the amount is not deposited, the requisites shall not be sent, and the matter be placed before us on Monday, that is on 15th of December 2025. Yes.
It may kindly be reduced, it will come in my head.
Without their appearance, presence, the matter cannot be effectively adjudicated. Yes, next.
Pardon, my lord. My lord, it may kindly be reduced, my lord.
Next.
Item 2.
You're giving it to bar only.
Item number
Sir,
2.
it will come in my head, man.
Yes, item number 2.
Kindly order dated 1/12/2025. Last one. Earlier, on 17/11/2025, the Lordship passed the exhaustive order indicating that since the same prayer has been allowed prior to my case and after my case was dismissed on the ground of limitation. Then your Lordship directed.
Last time we passed the order, Mr. Maharana
will take instruction.
Have you got it?
Admittedly that has been due to it is the interstate transfer issue. The approval of CBAT is necessary. That has been sent for approval. Filing the appeal.
You are going to challenge it. That's what you are saying.
Yes.
It's not yet challenged.
Not yet challenged. Admitted not actually.
Milord,
But
But
that order was
in fact, they
passed.
cannot challenge because
Just
catch up my
whether they cannot challenge or that is their decision.
my
We just wanted to know that whether the order dated 24/9/2025 uh, that was passed in the case of Swanso has been challenged or not.
Yes,
So 3 months have not passed. Your SLP period is still there.
yes.
No,
They
this
must
is
be.
no, no, sir, I mean,
They
85.
filing petition.
Yeah.
Let him shift to another.
Oh, अच्छा, they will file the अच्छा read petition you will.
Read petition.
File petition.
But that the tribunal has been directed to implement it within 90 days. That
Hmm.
period should be
That period according to you is also not over.
not over. That the 24/12.
You are right. So then let us keep it to January and see that are you whether you are implementing it and or you are challenging it before this court.
Yes, yes,
right. It is to be filed before this court.
Milord,
So let us see that order. Have you got the copy of that order? 24/9/25.
Yes, yes, sir.
Just 3 months you say that.
My lord, that
I have
order
given that
Where is that?
last topic.
24/9/2025 order has been passed.
କୁଆଡେ ଗଲା ସେ order ଟା କୁଆଡେ?
ଦେଇଥିଲେ ବୋଧେ
ମୁଁ ଦେଇଛି
ହଁ ଏଇଟା ଅଛି କୋଉ paragraph ରେ 3 ମାସ?
my lord, last paragraph, page 15, last but one paragraph. The entire exercise has been completed.
The
May
Mr. Vishwajit Maharana, senior panel and senior panel counsel, appearing for the opposite party, submits that there is no dispute that the Land and Central Administrative Tribunal cutter, bench cutter, in the case of Ajay Kumar Biswal versus Union of India and others in OA number 260/00584 of 2022. Has directed the opposite parties to consider the promotion of
Shri Ajay Kumar Biswal
Ajay Kumar Biswal to the post of senior tax assistant by holding review DPC for the year 2000-2001 and for subsequent years after taking into account the regular service rendered by the said applicant prior to his transfer to Odisha charge for the purpose of eligibility for promotion nationally, but it was directed that the entire exercise shall be completed within 90 days from the date of receipt of the copy of the order. And such period has not yet expired, and decision is yet to be taken whether to comply the order of the Land Central Administrative Tribunal or challenge the same before this court. And therefore, the matter may be taken off in January so that we'll be in a position to apprise this court regarding the decision taken by the opposite party. Put up this matter second week of Sommar. Yes, next pledge.
Item 3.
May it please your lordships. My lord, am I visible and audible to this honorable court?
Yes.
Yes,
Yes. I may be permitted to appear virtually in your lordship's leave. Oblige. Lord, there is one main matter and one IA.
Yes.
Yes, well, one main matter and one IA. IA is, my lord, the CAT Katak has imposed a cost of 20,000 rupees on the CBIC chairman, respondent 2, with a further direction that the chairman from Delhi should appear before it tomorrow for non-compliance of its order, which is in your lordship's court by way of an appeal. So, my lord, we'll pray for two things in your lordship's court immediately. My lord, I will show your lordship's earlier order and one doubt your lordship has expressed very clearly in law, which now we will be able to clarify. If your lordship takes your lordship's order, my lord, 23/6/2025.
Okay, 23/6/25.
Yes, 23/6/2025. But this is a case where somebody was suspended when they were in service, and my lord, he was allowed to retire. But, my lord, a case of disproportionate wealth acquisition was found both by the CBI and departmental proceedings. CBI has initiated criminal proceedings and department has issued the charge sheets. All this is post-retirement. So the tribunal went on the presumption, following principal bench judgment CAT Delhi, that once suspension, during suspension when somebody retires, then, my lord, and nothing has been done at the time of retirement.
But that was without the initiation of the departmental proceeding,
Yes.
and during the period of suspension, the retirement was made.
But absolutely, my in fact, your lordship has come directly to the point. Please come to second page of your lordship judgment. This is the doubt your lordship has very clearly expressed. Now the answer is in law. My lords have expressed a doubt. The factual scenario of the aforesaid case.
Just a minute. Just a minute. Additional liability is not with the file. No, it's there. Yes. Order is there. No. He is reading the order. Pursuant to vis-a-vis to that, we have filed additional affidavit with all documents.
My lord, the rules. My lord, I want to show two rules. That's all. My lords, my lord, it's a very my lords have pinpointedly pointed the doubt and we'll answer. It's not difficult at all. My lords are right in raising this doubt. It's our duty to, my lord, clarify. The factual scenario of the aforesaid case, which was relied upon by the learned counsel for the petitioner, is different from the present case, in as much as still the opposition party retired on 31/1/2022. No departmental proceedings were initiated against him, and it was only initiated on 1/11/2024, as stated by the learned counsel for the petitioner. Lord, the distinction between Delhi High Court and the present case, which your lordship has been brought, may I show the Delhi High Court provision, 72 pension rules? What was before the Delhi High Court was Rule 9, subclause 6, subclause B. Whereas what was not brought to your lordship's attention on the previous hearing on June 2025 is Rule 9, subclause 6, subclause A.
Yes.
They deal with two different situations. It's a very
let us see that.
doubt my lords have raised. I'll show it clarity. My lord may see the 72 rules, which are now in 2021 rules also will not relate.
The rules to it.
Yes, I have given this.
Yes. My lords will see 72 rules. My lords may come to Rule 9.
Rule 9. Yes.
Yeah. Right of the president to withhold or withdraw pension. My lords will come to Rule subclause 4. In the case of government servant who has retired or attaining the age of superannuation or otherwise, and against whom any departmental or judicial proceedings are instituted, or where departmental proceedings are continued under sub-rule 2, a provisional pension as provided in Rule 69 shall be sanctioned. So, 9.4 contemplates two situations. One is departmental proceedings.
So that is that decision was based on this particular rule. That decision which was passed by the.
Then, my lord, this is clarified. 32 rules. I will now show 2021 rules also. It's identical. Deco was Rule 9.4 note.
Yes.
Rule 9.6 B. because criminal proceedings have been initiated.
Connectivity
A.
issue, Mr.
If your lordships, that's why court contemplates two situations. My lord,
There is some connectivity issue, Mr.
am I audible?
Your voice is not audible because of the connectivity issue.
My lord, am I audible now?
Yes,
Yes,
you are audible. Yes, please.
So sorry, my lord. I'm trying. I'm so sorry, my lord. My lord, nine subclause 4 has two parts.
Hmm.
In the case of government servants who are retired and attaining the age of superannuation otherwise, and against whom any departmental or judicial proceedings. So both are contemplated under 9.4. And 9.6 has again two parts, subclause A and subclause B. What was, my lord, the case which fell for consideration in Delhi High Court was subclause B. So please see, my lord, rule 6, I will read. For the purpose of this rule, A, departmental proceedings shall be deemed to be instituted on the date on which statement of charges is issued to the government servant or pensioner, or if the government servant has been placed under suspension from an earlier date on such date. This is as far as department. Now come to judicial proceedings. In the case of criminal proceedings, on the date on which complaint or report or also which magistrate takes cognizance. In the case of civil proceedings, the date of plaint is presented. So that was the case of Rule 6B, subclause 1, where criminal proceedings were initiated. So, Lord Justice Khanna, as he then was, held it. Since it has been instituted, it is governed by this, and therefore, our case is not under 6B, it is 6A. The case on hand in your lordship's court is 6A. 6A, very clearly.
Second part you are covered.
My lord is absolutely.
Second part you are covered.
Second part. And similarly, this
if
is
the government servant has been placed under suspension
from an earlier
date, you are covered by that.
Yeah, very much. And this rule is continued under the 2021 rules. The same rule. Now we are governed by pension rules 2021. Please, rule 9 has become rule 8. Please come to rule subclause 8, my lord, explanation.
8.
Same, whatever is earlier rule 9.6 A and 6B now has been, my lord, virtually body lifted and made into explanation to rule 8.8. There's an explanation after 8, subclause 8. For the purpose of this rule, 1A, department proceedings shall be deemed to be instituted on the date on which statement of charges is issued to the government servant or pensioner. The government has been placed under suspension from an earlier date on such day. Same provision. So 72 rules as, my lord, modified by the 2021 rule.
Come to the order of the tribunal.
Yes. Lord, please see the order of the tribunal, 23/7/2024.
23, no, it is 26 for us. 26/7.
26/7.
Yes, 26/7. My lord,
what was his prayer before the tribunal?
Lord, he only wanted that it has to be quashed because he's retired. And my lord, that is precisely what they have done. My lords will come. My lord, it's the judgment start, the findings start from paragraph 5.
What is the original application copy, Mr. Pari?
Lordship, they have not supplied. I have brought it, your Lordship. May I submit?
Actually, it was initially filed in Ranchi. So we have not filed, we have not able to know. Then it was transferred to the
right. But if he has got the copy, just let us see.
Along with they have not my rejoinder and written arguments before the tribunal. They have not.
No, it's all right.
All of them.
I'm now today, my lord.
A copy.
I think a CBSE chairman should not be summoned by a tribunal with a cost of 20,000 to appear before him tomorrow. We have not committed any such. Yes, lordship should stay this and stay the order. And I'll show prima facie case at the moment.
Please, page 58, para 7.
My lord is right. My lord is para 7. So, and they are relying on, if your lordship comes to the earlier paragraph, they are relying on this Surinder Kumar Gupta's case, Delhi Cat, 3726 of 2013, which was reversed by the Delhi High Court. Of course, Supreme Court restored it for the reason the accused in that case was finally discharged by the CBI, and therefore on merits they said you restore him. That's a different question. But the issue on law decided by the Delhi High Court does not stand reversed by the Supreme Court. It does it. So the decision of the principal bench CAT, which is relied in this order in para 6, they rely on the CAT order, stands reversed by the Delhi High Court. I will show the Delhi High Court judgment, my lord, which your lordship has seen it on the last occasion.
Lordship, it's annexure P1, your lordship.
Annexure?
Annexure R1, your lordship.
In which volume?
Volume 1, page 11 to 48. Yeah.
Volume 1, page
11 to 48.
11 to 48. And that
prayer clause, your lordship, is that
where the relief sought for?
Relief sought is at page 38, your lordship.
38.
It was to quash and settle the suspension order.
Just
That's right.
38. Yes, please come to that prayer.
Para 8, your lordship, 8.2 to quash and set aside the impugn suspension order dated 22/11/2019.
Yes.
That is 41.
Yes.
Then
And then consequential relief, your lordship, that much
to
only.
pay the salary and other allowance for the period of. So what was allowed by the learned tribunal?
Your lordship, by influx of time, by the time this came up for hearing, he was already retired.
Achha, then
Therefore, they said that that period has to be treated as duty, have to pay him. And your lordship, before my learned friend, we learned from
yes,
them.
just a minute. Richard, he has not completed his argument.
Yes, only one thing.
Please come to that paragraph number 7 once again.
Yes.
Of the
impugn order.
Yes.
And if possible, para 6 also, because they rely on the CAT judgment.
Yes, read para 6 also. No problem.
Yes, I read, my lord. Subsequently, similar question as to whether, while continuing under suspension, allowing an employee to retire and attaining the age of superannuation without any objection, the order of suspension automatically gets revoked after the relationship of master and servant ceased to exist, came up for consideration before CAT New Delhi in Surendra Kumar Gupta versus the CAT Principal Bench New Delhi, taking into consideration the earlier decisions in the case of R.S. Nayak and H.I. Mehta and various provisions of the pension rules, 1972 and fundamental rules, so and so. But order dated 22/2015 held that since the applicant therein, while under suspension, was allowed to retire by the respondents and attain the age of superannuation without any objection, the earlier period of suspension automatically got revoked and the relationship master between the government and the employee ceased to exist on retirement and his status as an employee get altered. Accordingly, the respondents therein were directed to release the benefits to pay the allowances. And then this judgment of CAT stands reversed by the Delhi High Court, which, my lord, will get it in my set, in my lord, as Annexure 7, page 125. So it's a overruled judgment
what has been held ultimately? Paragraph number 7.
7, my lord. They allow, they give the relief. Yes, I'm sorry. I should have read that also. I'm so sorry. Paragraph 7, my lord, it says finally, on examination of the facts and issues involved in this case, vis-a-vis the case law referred to, we do not find any ground to differ from the view already taken by the principal bench. Since the applicant in the instant OA, while under suspension, was allowed to retire by the respondent attaining the age of superannuation without any objection and without any initiation of departmental proceedings, the order of his suspension automatically spends its force, becomes redundant, ceases to exist, resultantly entitling him to pay and other allowances for the period of suspension as is spent in duty. Hence, the respondents are directed to pay the applicant his salary and allowance with effect from his date of suspension till retirement of the course, minus subsistence allowance already paid to him within a period of 60 days from the date of receipt of the order. So they
what
clearly
happened to that judgment?
You say the relied upon judgment is reversed by the High Court.
reversed by the Delhi High Court. If your lordship sees,
let us see that.
Yes,
Lordship, additional affidavit filed, the judgment is also there.
yes,
Page
my lord.
137.
Yes.
Additional affidavit.
It starts, sorry, it is end on 137. It starts from
125, Annexure 7.
yes, 125.
125, Annexure 7.
Annexure 7.
Yes.
Have you given a copy to the Land Council?
We have filed the
You have given.
no.
How can you file a?
This, yes.
Please give it hand over. Land Council, please come to page 120.
Yes. Yeah, let my friend also be assisted. Yes. But once you come,
this one.
yes. And my lord, please see
What is that operating part of that
Yes,
order?
my lords will come to paragraph 9. Paragraph 9 refers to Rule 9.4 of the 72 rules, which we read it in your Lordship's court 10 minutes back.
Yes.
Yes. Then, my lord, Rule 9.6b. My case is 6a. The case before the court was 6b.
Come to page 14, para 14. Para 14.
Para 14, I will come directly to para 14.
Yes.
Deeply obliged. When we harmoniously read the aforesaid provisions, it is crystal clear that the suspension period does not evaporate and is not erased when the government servant retires, as in the present case. The respondent was facing criminal prosecution. The judicial proceedings stood instituted on or before the date of retirement. On the date of retirement, they were pending. In such circumstances, 9.4 of 1972 rules would apply with full vigor and force. It will also mean that the period of suspension in terms of 23 will not be counted unless the competent authority passes an order and declares the suspension period that shall be counted. Retirement thus put an end to the order of suspension for the reason that the employer-employee relationship ceases to come to an end. Once there is termination of the said relationship because the employer has attained the age of superannuation, the suspender order cannot continue, for suspension itself postulates existence of an employer-employee relationship. Retirement would not affect the earlier order of suspension, and the suspension order does not terminate the said employer-employee relationship under 16 of the General Clauses Act. Reliance placed on 49 and so on so is inconsequential and not relevant for the purpose of present adjudication. What is payable and paid is a provisional pension and not pension. Provisional pension and gratuity is provided under Rule 64. Payments have to be made under 69 of the Rule so and so, so and so. Then they may not read the fundamental rule. Finally, my lord, they, after referring to all the case laws, para 21. Yes, so the order of the cat gets reversed and goes to the Supreme Court. Supreme Court, my lord, by that time, the accused gets discharged in the CBA matter, which your lordship will get it under 138 Annexure 8. So it was agreed by the department that now that CBA has discharged him, we will restore and pay all the wages. So when a court passes an order, if your lordship comes at 140 and paragraph 2 at 141, the department has filed an affidavit saying we will honor all the payments catalogued in paragraph 5, 1 to 6. And all the payments were made because CBA discharged him. So,
what is the present status of the criminal proceeding?
In this case, Lord, CBI has filed a charge sheet, and Lord, I think that it is pending in the Bombay High Court. It's in Bombay Court, Bombay Sessions Court. Yes, so that is pending. And Lord, may I only say this? Yes, if your lordship will come back one more time to the rule. And there is no discharge asset anywhere. So, my Lord, Rule 6, now the Delhi High Court had an occasion to rely on Rule 6b, which is slightly differently worded. Case has to be instituted. Whereas in 6a, my lords, as rightly pointed out, the second half of 6a very clearly says, if the government servant has been placed under suspension from an earlier date, then on such date deemed to have been instituted. And therefore, my lord, at the moment,
on the same, he has already entered appearance.
Yes.
So, it can be regularized, the matter will be
Lordship, if I may,
but now the some interim application has been filed.
Yes, my lord, one is again staying this order. Second, more importantly, the chairman of Central Board of Excise and Customs now must fly down to Cuttack and appear in person tomorrow as per the order, after paying 20,000 rupees, my lord, cost. That order your lordship will see, which we have enclosed also, my lord, is dated 23/10/2025. 23/10/2025 of the tribunal, which we have moved an IA for stay. Taking into consideration the personal prayer of the learned counsel for the respondent, no order to the effect is being passed today. However, a cost of 20,000 is imposed on respondent number two. Not respondent number one is Revenue Secretary, Government of India,
Yes.
and respondent two is not
I
CBS.
is 20345 of 2025, flag B. The order,
Yes, sir. Yes, sir. May your lordship submit something before? I understand that. That is what I am trying to explain, your lordship. The personal appeal was not because of non-implement of this order. Thrice before the tribunal, they made a statement that we are implementing the order. Then they, yeah, that's right. Therefore, I am not taking these points. But one point, your lordship, my learned friend, my senior, was talking about the rules. Before reading Rule 6, Rule 4 of that rules may be seen.
Everything is now placed.
Lordship, it's not a very big issue. Your lordship will just. No, I will not insist on that, your lordship. That is a small matter, your lordship.
Where is that order? Asking for personality.
Yes, 23/10/2025. And it's along with the IM law.
Order is not
previously, Mr. Amitabh Das is appearing. That's why I'm sorry, my lord.
I'm so sorry, my lord. I'm extremely apologetic.
Noted so, but
you have a copy given.
Yes. I'm so sorry. I'm so sorry.
it is. I'm just passing.
Yes. Well, only two paragraphs. If your lordship gets the order, I'll just read only two paragraphs.
Lordship, no, I don't have. But what they're saying
Yes,
is right. I don't dispute that.
I'm just.
I'm not very interested in punitive action. I'm more interested.
Yes, but last two paragraphs. Taking into consideration the personal prayer of the learned counsel for the respondent, no order to the effect is being passed today. However, a cost of 20,000 is imposed on respondent number two. Not respondent one is Revenue Secretary, Government of India. Respondent two is CBIC Chairman, Central Board of Excise and Customs Chairman. And the respondents are further directed to file full compliance report or stay order if any of the Honorable High Court by next date of hearing, failing which respondent number two shall positively remain present before the tribunal tomorrow. 11/12 is tomorrow at 10:30. Lordship may kindly stay this first.
Please see what Priya what has been made in the interim application, which you are facing today. It is not staying for this personal appearance. It is only for staying that cost.
Oh, my lord. Lord, both we need to have. We need to. I don't know. But I'm very surprised that Mr. Pari's panel counsel are also not supporting him. I'm very surprised to see this situation. Not
This is unfortunate.
very
In the course of the day, I will find. In the course of the day, I will find.
The tribunal with regard to the imposition of the cost of swan.
20,000. Yes.
No other prayer that is personal appearance.
Course of the day, I am filing.
very unfortunate. I mean, we see a sad picture. I apologize.
Yes.
Stop him from panel.
And I'm apologizing for them today. The course of the day, I am filing. Yes. I apologize for this.
IN number 20345 of 2025. This is an application which has been filed by the petitioner. It is fair for a direction that the order dated 2025 of the learned tribunal with regard to the imposition of the cost of rupees 20,000 on respondent number may kindly is the custom. Stop. The copy of the order dated 23/10/2025 has not been annexed to the interim application. It was produced before false by Mr. Bhari and Deputy President today. And through the Lenin N. Venkatraman, praised for the stay of personal appearance of the respondent number 2 before the London Central Administrative Tribunal. There is no such prayer made in the interim application. The London Counsel for the Union of India, Mr. London Deputy Solicitor General, submits that he will file a praise interim in course of the day and the impugned order and serving a copy on the Land Council for the petitioner. Stop. The London Council for the petitioners filed an affidavit, additional affidavit, affidavit, the additional affidavit, annexing some documents which are taken on record. The London Council for the opposite party, एवढा किए फाइल कले एवढा आपण
ଆମେ କରିପାରିଲୁନି ସେମାନେ କରିଛି
the Land Council for the opposite party has also filed the
along with the small written submission,
some written note of submission along with the
pleadings of the
outcome file written
rejoinder
and the other documents which are also taken on record. In case in case this interim application is filed today during course of the day.
Today will file. I assured that it will file today.
Same shall be placed before us on 12th of December 2025 for orders. However, the London Council for the petitioner as opposite party submits that the opposite party is not interested in the personal appearance of the
chairman, respondent number 2.
Respondent number 2.
Petitioner number 2.
But he is interested in the that the order of the London Tribunal is to be complied with. In view of such, since we are taking of this matter on 12th of December 2025, subject to filing of the fresh interim application by the London Council for the petitioner, the London Tribunal shall not insist for personal appearance of the respondent number 2 tomorrow.
Chairman CBS.
And also the cost will
Chairman CBS.
Respondent number 2 कौन था नाम लिख दे
CBAC chairman CBAC.
Chairman CBS.
Respondent number 2 is
Chairman Central Board of Indirect Taxes.
He's right. So Chairman Central Board
BSc.
Indirect Taxes. Mr. Pari.
Vis-a-vis also imposition of cost.
Cost should not be stated. The government should not be so micro.
On the 20,000.
No,
it will Lordship may consider it later on, but time being it may be.
Lordship, after the year they file a writ petition when the contempt is filed. That is unfortunate if the cost would be.
That is user practice, Union of India.
No, that's what it is.
No, my lord. What happened from the, it was filed initially Jharkhand. Again, it was transported this place. So we don't have any record. I admit that some deficiency there with the department. I am not denying this.
Question is that when the Union of India is filing an interim application, how can such a defective application be?
I'm extremely apologized, my lord. I have twice
neither you file the order, but nor the proper prayer.
I'm admitting, my lord. That's why both the pass will go to the court for reference to
20,000 rupees.
Only one humble submission, if a lordship may have a look at the impugned order.
No, we'll take up this matter on Friday. We are taking.
Lordship, only one request. Can it be taken at the end of the board? My mother's charge is there on that day.
Yes.
12th. My mother's shad is on 12th. At the end of the board, so that I'll finish the shad and then come.
No, you around 11. Take up this matter at 12 o'clock. The matter will be taken up at 12 o'clock.
Lord, this 20,000 can be dispensed, Lord. Otherwise, they will tomorrow. We don't know what this or what order will CAT pass. 20,000.
No, Lordship, I am there. I will be. I'll be saying.
You will be there, and we will handle.
I am there, here. I am never unfair to anybody.
Lordship may reflect one thing. We will file a petition. Same shall be considered by the tribunal.
We are handing over a copy to you. It's matter of if we have the order behind.
Yes,
himself was an officer, you know.
Yeah. How difficult it is. Trust your friend.
Mr.
Trust your
Pari is
friend.
very kind to me also. That was I never highly obliged.
Obliged. Extremely obliged for the patient hearing and angels.
Yes, ma'am.
I may be permitted to exit your
Yes,
lordship's
yes,
court.
please.
Deeply obliged.
Item 4.
Yes.
Petitioner challenging the order letter 27/3/2019 passed in OA number 521 of 13 and order letter 3/12/2024 in MA number so Myla by the London Administrative Central Administrative Tribunal by dismissing both the MA, thereby not restoring the OA marks. Annexure 7 is another challenge one.
Yes. We allowed your prayer for amendment.
Yes, ma'am.
And also directed that the consolidated writ petition is to be
That is
filed.
already been filed.
That has been filed. And have you served the copy?
Yes, ma'am.
Yes. So what was your prayer before this court to challenge the order dated Annexure 10 you are challenging?
No, my lord, that has been in my amendment application. That is Annexure 9, my lord.
Just a minute.
Annexure 9 and Annexure 7, my lord.
But come to your consolidated writ petition,
Yes, sir.
page number 10. See the prayer portion. Annexure 10 লেখা ହେଇଛି shall not be set aside. ତାପରେ ଅବଶ୍ୟ ତଳ ଆଡକୁ ଲେଖିଛନ୍ତି Annexure 9 ଆଉ Annexure 7. So ଆପଣ କଣ ଚ୍ୟାଲେଞ୍ଜ କରୁଛନ୍ତି?
I am challenging the Annexure 7.
Then why have you mentioned it 10, 9, 7?
I mentioned in my amendment petition, my lord.
Amendment ଯୋଉଟା ଇଏ ହେଲା ତାକୁ incorporate କରିବେ ନା ସିଏ ଫାଇଲ କରିଦେବେ? ଯୋଉଟା ଆମେ incorporate allow କଲୁ ଆପଣ ଗୋଟେ schedule ଦେଇଥିବେ prayer schedule ଟା ହବ ଆମେ ସେଇଟାକୁ allow କଲୁ ତ ସେତିକି ଆପଣ incorporate କରିବେ ନା ଯାହା ମନ ଆପଣଙ୍କର ଆସିଲା?
ସେଇଟା ହିଁ କରିଛୁ incorporate.
Then why are you telling that we have let us see your interim application for amendment?
Schedule of proposed amendment, my lord. Paragraph 9 in last line after the word 1987 along with the copy of the order dated 27/3/2019 passed in OA case number 521 of 13 by the Central Administrative Tribunal Court of Orissa and document of medical treatment, my lord. Be inserted in the same paragraph after the word Annexure 8 and Annexure 9 respectively.
Prayer portion ରେ କେବଳ amendment କରିବାର ଥିଲା ନା ଅନ୍ୟଟି?
Prayer portion ଅନ୍ୟରେ ବି ଥିଲା.
Prayer portion ରେ କଣ amendment ଆପଣ prayer କରିଥିଲେ? Where is that?
Last para. Similarly, in the prayer portion, Annexure 10 may be read as Annexure 9, my lord. After the word and consequently the order dated 27/3.
ଠିକ ଅଛି ଆପଣ କହିଲେ ଯେ Annexure 10 ଟାକୁ Annexure 9 ହିସାବରେ ଆମେ ତାକୁ allow କଲୁ। ତ ଆପଣ ପୁଣି କେମିତି ଯେତେବେଳେ consolidated petition ଟା ଫାଇଲ କଲେ ସେ Annexure 10 ଟାକୁ କେମିତି ରଖିଲେ?
That is MA mark. MA number 226.5. MA number 225. Because sequence delay, so you move another MA. But Canada is not delay. Yes, ma'am. Both the Canada is not delay application as well as the reference application district. Yes, ma'am. By the order of this board, the order of the site, it's a 10. 10, ma'am. So challenging that 10. Why are you bringing so many things? I don't know.
Why are you telling now that you are not challenging an actual case? Zero want a challenge to you. পর্যন্ত সেই অর্ডারটা বর্তমান ভাবিব অরিজিনাল অ্যাপ্লিকেশন তো ডিসমিস করলাম তারপরে আপনারা এই এগ্রিমেন্টটা ফাইল If on that miscellaneous application to miscellaneous application given on certain part on an annexure 3. So you are rightly challenge annexure 8. Along with annexure 10, you can also challenge the earlier order. Let us say that the last order that is annexure
7.
But you cannot leave annexure 10. Annexure 7 for this annexure 10 has आपण annexure 10 টা সেটা সাইজ করতে কিন্তু পৌঁছি পারি annexure 7. ঠিক আছে So you can clearly write all right then proceed.
Ismail, on 2 for 2024, after a lapse of more than 5 years from the date of dismissal of the OA, on 27th, 27, yes, yes, non-prosecution. You moved the application after 5. Mile. Next 3 mile. The grounds stated in MA as repeated by the learned counsel for the applicant in course of hearing are that due to his illness, he missed the list when the matter was listed, and MA depend upon his associate who also lost sight the matter was listed on 27 March 2019. The applicant is a resident of Bolangir. He was engaged in the treatment of his wife from January 2019 to 20 January 2023, who was suffering from cancer and ultimately died. In the above circumstances, he did not notice that the matter was listed on 27 March 2019, and thereafter, due to the mental pressure and financial disability, could not contact his advocate till March 2024. Further stand of the applicant is that his file was misplaced during the shift of chamber of his advocate from Badambadi to Jagat.
Advocate was this piece of it. Second, upon the third, I missed all that. How much ground I think there is a delay of 5. If your advocate is at fault, have you initiated any proceeding against him in the bar council? Why will accept this delay explanation? When this stipulated period is prescribed, that under within what period you are to file an application if the matter is dismissed for non-prosecution. Advocate list Mr. More than 30 July was filed. So 30. And then 2019 dismissed in default during APS. After the result obviously upon filing for the we accept this. You are supposed to be vigilant. And if you are not vigilant, you would expect to lead from the this person had a contract with the team. Obviously, what are you mobile and that's your mobile and you then go to we say that It has not been modified. But I think that every order which is disposed of that so there is a provision that order is to be communicated to the party concerned.
That is reflected in the order. The registry has given a report that the order was published.
So the matter was dismissed before the 27th, 2009. Why they are lying that is so?
Para 4. I'm placing my lord. Appearing to the other side has submitted that the grounds stated in support of the prayer to condemn the delay and restore the file for hearing in OA is no ground to restore the OA. It is stated that the order of termination is 19/12/2012 and OA has dismissed on 27/3/2019. Thus allowing the same at this related stage to ultimately unsettle and settle matter after long lapse of time. It is submitted that the applicant has stated that he was engaged in treatment of wife, but nothing has been stated for the fault of the concerned advocate, his associates for non-appearing on consecutive dates when the OA was listed or for not taking steps for dismissal of the OA. Further, no plausible explanation is also furnished by the applicant for the delay caused even from January 2023 till the date of filing MA on 4/2024. Neither any such affidavit or document has been filed by the concerned advocate or non-appearance on the date when the matter was dismissed for default or regarding missing of the file, which is serious in nature. We therefore feel that great injustice will be caused by allowing the prayer paid in the MS. That was the money that I am going to pay. I am just listening. The matter was issued. Your Lordship, sorry, my lord, the first paragraph was the OA was listed on 7/10/2019. That's you got it. But no one was present for the applicant. Thereafter, the matter was listed on 27/3/2019. But since no one was present for the applicant, on that day also, the OA was dismissed for default. 3 copies of the said order was also issued on 29/3/2019, as it reveals from the notes of the registry. To the party, my lord. Party, person concerned.
ସେ କହିବା ଅନୁସାରେ in OA for reinstate and the consequential benefits granted. Yes, ma'am.
What is your age now?
Now 46, ma'am. The poor person belongs to a category.
How can we overcome this regime which has been assigned? Where is your that application which you have filed? Miscellaneous application.
Annex 8 things, ma'am. Page number 30. The advocate of the applicant was ill on those dates and could not see the list and depend upon his associate for which he and his associate lost sight of posting the case for here. Medical documents, my lord, is started from my lord page number 37. Yes, ma'am. No, my lord, page 37 of my
Consolidated
consolidated. Repeat, sir. Page 37 to my lord, may I kindly see the is 39 minus Harihar Regional Cancer Center. Yes, ma'am.
The last medical document shows that the treatment was made on the 6th of India 2020. For a big portion of the document, how you 21 document are cheapest 60 days. The time followed by Asoba. Years you have not you are busy in the treatment of the body of which we sound on the detail.
No death certificate is also filed. No death certificate is.
That is quite a lot. This writ petition has been filed by the petitioner Premanand Nag with a prayer for setting aside the order dated T12-2024 passed by the London Central Administrative Tribunal, Cuttack Bench, Cuttack. In MA number 260/00225 of 2024 and MA number 260/00226 of 2024. In dismissing both the miscellaneous application stop. Needless to say that MA number 225 of 2024 was filed for restoration of way number 521 of 2013, which was dismissed for default or non-prosecution on behalf of the petitioner. On 27/3/2019, and MA number 226 of 2024 was filed to condone the delay in filing the miscellaneous application, that is MA number 25 of 2020. Stop. The original application, where is the copy of that OA? Have you got a copy of the OA with you?
No.
Huh?
OA copy is not with me.
No. The original application copy has not been annexed to the writ petition. So you cannot say what was your prayer there.
My lord,
You're not having a copy.
I got the certificate copy, my lord.
Don't have it. It is a standing order to file all the documents. number 521 copy. In the OA number 52 and so on, sir, 2013, the with the Land Council for the petitioner, however, filed the copy of the original application, which is taken on reference. In the said original application, the prayer was made before the tribunal to set aside the order dated 13/5/2013 passed by the Divisionary Authority and Additional Divisional Railway Manager from opposite party number 2. Also order dated 18/3/2013 passed by the Appellate Authority and Divisional Mechanical Engineer, Sambalpur, and also the order of removal of the petitioner from service dated 19/12/2012 passed by the Disciplinary Authority and Assistant Divisional Mechanical Engineer, East Coast Railways, from opposite party, Sambalpur, opposite party number stop. ସେ ଯୋଉ ଅର୍ଡରଟା ଦେଖଉଥିଲେ ଆଗରୁ ଲିଷ୍ଟ ହେଇଥିଲା ବୋଲି କୁଆଡେ ଗଲା ସେଟା ଯୋଉଟା ଆଚ୍ଛା it appears that the OA was listed on 17/1/2019, but nobody was present for the petitioner, and accordingly the matter was adjourned and it was listed again on 27/3/2019. But since no one was present on that day also, the OA was dismissed for default. The order dated 27/3/2019 is quoted here in below. That is in page number 28. The miscellaneous application by MA number 225 of 2024 was filed on 2/4/2024. For restoring the OA number 521 of 2013. And grounds have been taken that since the advocate of the petitioner was ill on 27/3/2019, he couldn't see the list and depended on his associates, for which they lost sight of posting of the case for hearing on 27/3/2019. It is further stated that the wife of the petitioner was ill, for which he was engaged himself to give her medical treatment from January 2019 to 20th January 2023, on which date his wife expired due to chest cancer. it is further stated that after the death of the wife, the petitioner forgot about the pending case in the tribunal and did not come to meet his advocate due to heavy mental pressure and illness, and also on account of financial disability. From 2019 to March to 2024. And ultimately, the appellant, after inspection on 27/3/2014, came to know that the case was dismissed for default on 7/3/2019. It is stated that neither the petitioner nor his advocate knew about the posting of the case on different dates for hearing, and therefore their non-appearance was not intentional, and that the petitioner had taken all due care and caution for prosecuting the case since 2013, and that there was sufficient cause for non-appearance on 27/3/2019, and accordingly prayer was made to restore OA number 521/2013 to file and post it for hearing. The miscellaneous application, which was filed with MA number 225 of 2024, was registered as MA number 226 of 2024, in which prayer has been made to condone the delay that has occurred in filing the miscellaneous application number 225 of 2020. Stop. The Learned Tribunal has been pleased to hold that the order of termination is dated 19/12/2012, and the OA was dismissed on 27/3/2019, and therefore allowing the miscellaneous application at the belated stage would ultimately unsettle a settled matter after a long lapse of time. Though it is stated that the petitioner was engaged in the treatment of his wife, but nothing has been stated regarding the fault of the advocate oblique his associates for non-appearing on the consecutive dates when the OA was listed, and for non-taking steps after dismissal of the OA. The Learned Tribunal found that no plausible explanation has been furnished by the petitioner for the delay caused even from January 2023 till the date of filing of the MA on 2/4/2020. Further, no acknowledgement document has been filed by the concerned advocate for his non-appearance on the date when the matter was dismissed for default or regarding missing of the file. The London Tribunal came to hold that after the dismissal of the OA for default, a free copy of the order was issued on 29/3/2019 as revealed from the notes of the registry. Therefore, the London Tribunal was of the view that allowing the error made in the miscellaneous applications at the belated stage to adjudicate a dispute which was set at rest since 2012 and finally after dismissal of the OA for default in 2019 would not be proper, and as no sufficient cause for not prosecuting the OA was shown. Accordingly, both the miscellaneous applications were dismissed. The Land Counsel for the petitioner repeated the same argument which were advanced before the London Tribunal during the hearing of the miscellaneous application. And he has also produced the medical document to show the element of the wife of the applicant. But it appears that those are the documents in which to show that the wife of the petitioner was given treatment in where is that documents?
Page 37 onwards, my lord, in the consolidated reports.
Before. In 2019,
and 20.
and 2020.
21 miles. 31st August 2021. With 62 pages. Page number 62.
And the last document was the ultrasound report, which is dated 31st August 2020.
Yes.
When a case has been instituted by the petitioner before the Central Administrative Tribunal way back in 2013, it was his responsibility to keep in touch with the London Council and from the orders passed by the London Tribunal time to time, it appears that the petitioner was not vigilant and therefore shifting the blame on the advocate that he missed the list or that the wife was under treatment for from 2019 till till her death, which is not backed by proper documents. We are of the view that the London Tribunal has not committed an error in passing the influence orders. The decisions the party is not vigilant what would happen to decisions. Accordingly, the writ petition being devoid of merit stands dismissed. Draft copy yes.
Item 5.
Item 5 and 55 can be taken up together in another day. Mr. DHA argue this matter. Item 5 and item 35. Similar issue is there. Can be taken up another day.
Taken up when?
Next week.
Taken up together you are saying, but you want next week.
Right.
35 and 5.
35.
They are not paying regular salary.
As per instruction,
yes.
As per instruction, they already paid, man. Up to June 2025, we have paid, but from July 2025, they are working on the outsourcing and they have
already instruction achi June 2025 parjanta. Tanga salary payment is
by the department and others are paid by the outsourcing. That's why I am taking time to clarify all.
From July 2025 onwards, the payment has been made by the outsourcing.
Yes.
That is your point.
But not the amount which you are getting. We are getting 1275 per day.
That's why I'm
9 to 10 days.
You file an affidavit to
that's why I'm taking time for
madam. You are filing today during course of the day, that affidavit.
Within 3 days, madam. 7 days, madam.
The London Council for the Union of India. You are Mr. Das S.R. Amit Kumar Sir, London Central Government Council submit that this matter is connected to number item
34.
389 of 2025.
Just a minute. 35. That is WPC number 23898
of 2025
of 2025, and it may be listed together. He further submitted that instruction has been received that petitioner has been paid his dues till June 2025 by Doordarshan. Doordarshan / Prasar Bharati, and thereafter he has been paid
up to
October 2025 by the outsourcing agency.
Yes.
And to that effect, an affidavit will be filed within 3 days. Let a copy of the affidavit be handed over to the London Council for the petitioner for obtaining instruction. Put up this matter on 17 तारीख में हमें रोकी थी.
Within 7 days.
पहले 3 दिन भीतर फाइल करें, 7 days.
80 per
Same amount they are not paying.
7 days.
Acha, within 7 days.
We are getting 1275. Now they are paying 730 through outsourcing.
Around 22nd of December 2025. Just a minute.
And the 35 item
Also fix it to
75 item re
Ajay Kumar is
na lekhidebe etar olga Union of India se etar Mr. Amit Kumar Shah achandi setare apanakor na dei diontu matter asibo era form bora su bhagi no.
Let it to come in the last week commencing 27th.
22 तारीख पर 22 12/2025
Indicating the amount you are getting.
Also affidavit amount yes
Amount
file an affidavit regarding such payment indicating the amount which has been paid.
Yes.
Okay.
5 plus out again 31 na 35
35.
What rate is paid?
In the rate what yes we are just coming with input. Please.
Item 6.
May I please? My lord, I am challenging annexure 3 and 4. The order passed by the opposite party number 2, GRF Paradip, and the opposite party number 1, that is in annexure 5. My lord, I am the petitioners and myself resided outside of the state since the year 1998. But a electric connection was taken by my brother, who is in opposite party number 6 in my name, and now the dues was 85,000, for which the petitioner approached the opposite party number 2, and the opposite party number 2, without considering the details, only pass an order and directing to deposit 30% of the area amount and the rest of the amount in phase manner. And I am challenging that order annexure 4 before the opposite party number
No,
1.
disputing that the electric connection, you are not disputing that the electric connection was taken.
Yes, my lord.
And in your name it is taken.
Yes.
You are not disputing that there was outstanding dues.
My lord, that is outstanding due which is in my name when myself applied.
That is why he took in your name and why you signed the documents. That is up to you.
My lord, if they are producing the document, then I will
that that connection was taken in your name means you must have signed the document, relevant document.
That is in the year 1998, my lord.
Whatever it may be, without your documents, without your signature, if your brother signs,
yes, my lord, I am coming that part. My brother is fraudulently taken that line.
You have to prosecute your brother. You have to recover from your brother. Whatever you want to do it. This is a due you have to pay them. Because it stood in your name, and you had no objection. You allowed it to continue.
Milord, that is in Annexure 3. That was village panchayat was held, and my brother admitted.
Can this court go into all those things?
You can prosecute your brother. You recover from your brother.
Now I am unable to take the line. Otherwise, my brother was taken line in same plot, and the electric authority says that.
So, if the electricity has been taken in your name and you have defaulted, so they are bound to disconnect and you have to recover, give the charge. And if you apply for fresh connection also, they will insist on that first you clear the outstanding dues. That is the.
That is not within my knowledge. When myself applied in the year 2018.
We don't know. It may be a collision also between both the brothers. Then the third brother will come. He will do something.
In the opposite party number 1, I have filed a petition to submit all the document against which the electric connection is in my name. But they have not produced a single document. Basing upon this document, I have collected the electricity is in my name. So
you see the electricity connection, it's not that electricity connection was totally not paid. It must have been paid for some time, and thereafter there is the default is going on and on. Ultimately, that has come to 80,000, as you said.
85,000.
85,000. And whenever the receipt was also been granted, that must be also in your name, not in the name of your brother. And you are telling that I am totally unaware. My brother has done. My brother has taken in my name. I am not liable to pay. How can it be?
Because I am in since 1998 at Gujarat and working in a company.
ଗୁଜୁରାଟରେ ଯିଏ ଥିଲେ ତା ନାଁରେ ଇଲେକ୍ଟ୍ରିସିଟି କନେକ୍ସନ ନେଇ ପାରିବନି ନା କଣ କହୁଛନ୍ତି ଆପଣ ଯଦି ବାହାରେ ରହିଲେ ଆପଣଙ୍କ ଘରେ ଆପଣଙ୍କ ନାଁରେ ଇଲେକ୍ଟ୍ରିସିଟି କନେକ୍ସନ ନେଇ ହବନି but sort of free or taking and how they will now adjudicate all these matters when both the courts are giving the concurrent finding.
Kindly directed the court to reconsider the matter.
On what basis? Unless you show that there is culpability in some illegality has been committed in the adjudicating the matter. Why will remand the matter?
Yes, my lord. I am shouting the information that please provide me the document against which the electricity connected in my name. They are not produced a single document. So my submission, my lord.
You yourself said that the electricity connection has been taken in your name.
Yes,
but it has been some fraud has been committed by your brother, who is whom you have added.
That's why I am
party number 6.
Complaint before the police.
And this court is not a court where this fraud aspect is to be inferred into or a finding is to be given. If that, as my esteemed brother pointed out, you can initiate a proceeding against your brother. It's a different criminal proceeding, civil proceeding, whatever you may like. But
now
so far as
I'm unable to
electricity dues
connect
are
the
concerned,
electricity meter. This is the problem, Milord. Now I am unable to take electricity as because the GRF directed me to pay the
bill
30%
and
of the
take
area.
electricity.
You pay 30%. What to do?
Milord, I'm not.
And the rest of the amount will be adjusted in their future bills.
I'm not used this the electricity, Milord. That's why I'm.
All right, query that order. Let us see that operative part. The
operative.
Right. Annexure 5.
Annexure 5 is the final order.
Yes, Miller. Annexure 5, running page 27. With due permission, I'm reading those lines. It is presumed that the petitioner was visiting his village, though not frequently. The presumption of supply of electricity connection on the application of the petitioner can be taken, and this presumption can be shattered by mere statement of denial by making an application seeking any electricity connection in his name by the petitioner is not acceptable or believable. It is not conceivable that electricity connection can be provided 20 years back in the name of the person without actual application, though the conduct of the respondent for waiting till the arrear amount reached of rupees 70,000 is blameworthy to the respondent should not have waited for a long time without taking the steps for disconnection of the power supply. The so-called Panchayat copy of which has been produced, the petitioner is a private document. The fact remains that the petitioner is a record consumer and the liability on him cannot be withdrawn by same surmises respondent number 4 not the recorded consumer for the relevant period, and as such he cannot be saddled payment of arrear dues except the liability arising on his own concession in course conciliation. In view of the scenario stated above, it can be logically presumed that the petitioner had applied.
All right. The writ petition has been filed by petitioner Parikshit Singh challenging the order dated 26/7/2023 passed by the Grievance Redressal Forum Paradip. और केस नंबर किस था ना नहीं कहीं से केस नंबर तक है annexure 4
case number annexure 4 GRF/JD 26
अच्छा in case number लिखा है जोटा এটা লিখি দেবে GRF so and so and so also the order dated order কেবে কার এটা আচ্ছা order dated 28/12/2023 passed by the Ombudsman 1 OERC है ना
in consumer
consumer representation number OM so and so लिख देगा ना अच्छा देखो it appears that the petitioner approached the GRF What was your prayer before the GRF? Where is that application?
That is a plain paper application.
For supply of electricity to his premises and with a further prayer, disconnection of power supply recorded in the name of opposite party number 6, Niranjan Singh, who is admittedly the younger brother of the petitioner. Then in GRF, after considering the case of the petitioner and the submission of the opposite party, has been pleased to hold has been pleased to direct to the executive engineer, JED and SDO, Jagasimpur, his opposite party number
three.
Three.
Executive engineer election.
upon ଲେଖିଛନ୍ତି ନା ସେ ଯୋଉ order ରେ ଲେଖା ହେଇଛି, if you come to that particular order, opposite party number 1 ହଉଛନ୍ତି EE, JED and SDO. ତାହେଲେ ଲେଖିଦିଅନ୍ତୁ ସେ opposite parties number E ତ ହଉଛି ଆପଣଙ୍କର opposite party number 3 and SDO ହଉଛନ୍ତି opposite party number 4. ସେମିତି କରିଦିଅନ୍ତୁ opposite party number 3 and 4 ହେଲା। To restore the existing power supply connection recorded in the name of opposite party number 6 immediately after receipt of 30% of his arrear amount from the petitioner. And for the direction was issued to the said opposite party to allow suitable installment to the petitioner for clearance of the balance of his proportionate share as per the norms of OERC regulation. Stop. The petitioner challenged the order passed by the GRF before the Land Ombudsman, and the Land Ombudsman found that the order of the Land GRF is quite justified and there is no occasion to interfere with the same. And accordingly directed the opposite party to provide electricity connection to the petitioner strictly in accordance with OERC distribution bracket condition of supply bracket in code 20 कहते से ना
2019 election. 2019.
29. So, the London Council for the petitioner argued that the petitioner had never applied for electricity connection, but it was his younger brother, opposite party number 6, Niranjan Singh, who applied for the electricity connection in the name of the petitioner. And he became the defaulter. He submitted that the opposite party number 6 has committed fraud on the petitioner, and the petitioner has been wrongly treated as a consumer by the opposite parties. It is further argued that by recovering the dues from the petitioner would not be in the interest of justice, particularly when the petitioner has never taken an electricity line, and he should not be penalized for the mischievous activities of his younger brother from opposite party number 6. And therefore, both the orders passed by the GRF as well as by the Ombudsman should be set aside. When we put a pertinent question to the Land Council for the petitioner as to whether for the fraudulent activities of the opposite party number 6, whether the petitioner has initiated any proceeding in any forum, the answer was in negative. Whether the opposite party number 6 has committed fraud on the petitioner or not, this court is not the forum to adjudicate the same. Stop. The connection having been taken in the name of the petitioner, and since there was default, therefore the opposite parties number 3 and 4 are quite justified in raising the bills and asking the petitioner to make payment of such arrear dues and also disconnecting the power supply. We find no fault in the orders passed by both the authorities. And moreover, when the authorities have asked only for payment of 30% of the arrear dues and directed that the balance amount is to be paid by suitable installment, it appears that both the authorities have acted very liberally, and therefore, since there is no illegality in the orders, we are not inclined to interfere with the same. Accordingly, the writ petition stands dismissed. Yes, next. Please file your appearance memo or wakalatnama. Just now you filed, madam. Yes.
Today will file, Your Lordship.
Huh?
Today will file. We have instructions to appear on behalf of opposite partner.
No, if you want to record your name or you should file something so that we can mention your name.
Yes, Your Lordship. We'll
Or
file
the, yes, next.
Ma'am, please, Lord. Kindly pass over.
Which one?
Item 7. Item 7.
Next.
Item 8.
You have filed that interim application for amendment. Copy दे दीजिए शॉर्ट कर दीजिए
admission ହେଇନି
no ଆପଣ admission ନ ହେଇକି ବି ଚାହୁଁଛନ୍ତି ଆगे amendment ହେଇଯାଉ ତାପରେ admission ହବ so he's you are bound to supply a copy of the interim application, otherwise how it will be considered.
today I will
Lekhandu, an interim application has been filed by IA number so and so for amendment, but the copy of the application has not been served on
sole opposite
on this na koi
Lalit Kumar Mahan.
Please write it down.
Minus.
I'm like who has instruction to appear,
Yes.
and you will file the wakalatnama
By the next date.
by the next date, that is so and so. The name of the land council be reflected in the cause we stands for, and matter be listed. Kebe rakhiba kuhuntu.
1 week after.
1 week after. After year January report. Next.
Item 9.
Yes, Mr. Swine.
Well, the petitioner has paid 39 lakh 7,000 before the bank. As per their OTS.
Who bank? Bank of India. Mr. Koro, you are appearing. Have you received a copy of the?
No, just now.
So, what has happened in this case?
What happened, my lord? The petitioner has paid 39 lakh 7,000 for closure of both the loan accounts. My lord,
e-auction
e-auction they intimated that
Who are you? You are auction purchaser.
no. The
Borrower.
borrower.
So what happened? Whether that auction re कौन ହେଲା?
Auction re se intimate e-auction ହେଇଯାଇଛି and the auction purchaser deposited 25%. But thereafter, when I extended that I will pay the 39 lakhs for the OTS, they accepted my money until that yes. Regarding OTS auction, they have not intimated anything, and the possession with the.
So bank has accepted the entire amount.
I don't know. Just now I have received. I will take it.
All right, we'll take up day after.
My lord, article person concern is not available.
15th is Monday, or you want it on 17th?
17th.
17th.
He is not in the.
No, it's all right. A copy of the writ petition has been sought, Mr. Coral, who has instruction to appear for the opposite party bank, and he seeks some time to obtain instruction. Particularly the submission of the land council that the petitioner has deposited a sum of rupees
39 lakh 7,000.
Government nation the who paragraph
I have stated in paragraph number 12
that the petitioner has paid the entire outstanding dues of rupees 39.
What is my outstanding?
They are they have quote. Petitioner has paid the entire outstanding amount of rupees 39 lakhs 7,000 to the bank. Stop. The matter will be listed on 17th of December 2025. Yes.
Item 10.
Yes, 10, Mr. Mishra, Union of India, nobody is appearing from the Deputy Solicitor General's office.
Item 11.
May I please? Here in this case, the principal borrower died. He availed a loan of rupees 95 lakhs.
Who are you?
I am the brother of the principal borrower and a co-borrower.
Yes.
My lord. After the death, my lord.
Yes.
Because there is a insurance coverage to that loan account, I have submitted an application before the authorities stating that let the amount secured in that insurance coverage be adjusted against my loan account, my brother's loan account. They did not listen to that and not responded anyway to the petitioner. Thereafter, my lord, your lordship will find I will take, my lord, the insurance coverage. Your lordship may kindly turn to Annexure 6 at page 32.
The insurance coverage upon 5 in 5 that is to be decided by ICICI.
ICICI the insurance.
Right.
Yes.
ତେଣୁ ଆପଣଙ୍କର ସବୁ ପ୍ରିମିୟମ ଠିକ ସେ ଅଛି ନା ନାହିଁ ତ ଆପଣ
We have
ବ୍ୟାଙ୍କ
paid.
ଆପଣ ତାକୁ ତା ଦେହର ଇଏରୁ ଆଡଜଷ୍ଟ କରନ୍ତୁ. First of all, it is to be decided by the ICICI whether your brother is entitled to get the amount or not. That is to be adjudicated or not. But second, the direct bank.
My lord, may kindly see Annexure 6. That is why I want to draw
Annexure.
Annexure 6 at page 30.
Yes.
And that is the insurance coverage. It stands in the name of
Muhammad Abukar, the deceased Miller. And thereafter, your Lordship may kindly see page 33, next page. That table shows description, middle portion of that table. Second item, death and accelerated terminal illness benefit. I am coming, my brother's death coming under this condition. Death. Now, so far as the coverage of the loan is concerned, the Lordship would find.
So after the death of your brother, have you claimed that the benefit?
Yes, Lord.
So what happened to?
It is pending before that. They have not responded.
So you have grievance against them?
I have already deposited 16 lakhs some odd.
No, have they repudiated your claim? ICICI Bank has repudiated your claim.
No, they have not repudiated.
So then it is premature.
I have made application to that. The Lordship will find that
Your grievance is now mainly against that
ICICI and that bank.
Once ICICI will give, then only they will take it.
How can
no, they have to give instruction to the ICICI bank to encash that insurance policy.
Your cause of action will arise after the repudiation of your claim. There is no repudiation as of today.
What has happened, without repudiating my claim, they are deducting EMI regularly from my account, brother's account. 16 lakhs they have taken away like this, without responding to my application. I have applied, your Lordship. Kindly see.
Who is
page.
Their notice has not been issued.
Do you know who is this? You are appearing. Why don't you sort it out? If he is entitled to insurance, collect it and get your money.
I shall take instruction. Let him serve a copy.
No, we'll send it to mediation.
Yes,
so you have instruction to appear for whom?
John Small Spine.
They have to initiate it. That's what. You be in touch with that ICICI people. If they are entitled to insurance, you take back the money.
Please give your name and submits that he has instruction to appear for the opposite party number 1, Jana Small Finance Bank Limited. Let a copy of the writ petition be served on the Land Council for the opposite party number 1 by tomorrow. During course of the day, we'll obtain instruction to matter and also. Can it be taken off in the coming, if you take the instruction on by 12th, if we list it, then 13th there is National Lok Adalat. We can take up this matter. Because the ICCI people will also be there. And if it can be sorted out, then.
What is happening is installment stable. You could be my brother has died. You be in touch with the.
No, right.
You can't tell. At least they will do it. Then sort it out.
So we are keeping it on Friday.
Friday you come, we'll see.
Come and see and just have.
My lord, I have filed an interim application.
What is there on Friday? After tomorrow we are taking
to the petitioner. Your Lordship will find an annexure.
Day after tomorrow, nothing will happen.
12/12/2025. Yes.
12.
In Nahandle, give the name and also name should be incorporated in the first list. Yes, next.
Item 12.
Please, Miller. This petition has been filed against the order of the GRF and
Mr. Maharana, you have received the copy?
I have received the document. Denying to entertain the complaint on the ground that the same relates to an assessment. But the facts are like this. The petitioner is a consumer of electricity under medium industrial category of a tariff. The contract demand is 89 kilowatts. On an verification, they have calculated all the working assets apparatus and ideal apparatus in the consumer's premises.
Which order, in fact, you are challenging?
My Lord, Ombudsman's order.
Which is very that?
My Lord, annexure. That is, my Lord, annexure 13, my Lord. Page annexure 10 at page 44 to 47, my Lord. My Lord, I may permit to place the facts so that it will be very clear to understand, my Lord. My Lord, then they have brought it into my, taking all the assets apparatus into calculation, they have enhanced my, calculated my load as 147 kilowatt, my Lord, for which they wanted to bring me to large fold tariff, my Lord. When I was being billed under a medium category, they brought it me to my large fold tariff. And my Lord, preceding 1 year back, they calculated the demand. And they raised the demand of 1,24,000.
So that's just one line. If you come to the page number 47.
My Lord. 47.
47. The last paragraph of the operative part. In view of the averments and counter-averments of the parties, it can be reasonably held that the Ombudsman is not vested with authority in law to entertain the prayers of the petitioner as stated above. So he has held to be not vested with the power. So that is the thing which, because he has not adjudicated the matter.
He has not adjudicated the matter. A lot of what happened, what prompted me, the petitioner, to approach the first base level forum, GRF, my Lord?
Yes.
My Lord, they have raised a demand.
Yes.
As per section 126, they have raised a demand under 135. 135 is the theft. For that, for establishment of theft of electricity is concerned, special courts are constituted under section 154. And 154(5) says the special court will decide the civil liability against the person or consumer in terms of money so far the theft of electricity is concerned. This is the clear provision of law. And when you have made an allegation that I committed theft of electricity, you have raised a demand under the provision of 135, a demand notice under 135, my Lord. Then, my Lord, under section 126, my Lord, there is a provision that the assessing officer can raise a demand under section 126. His power is only to be exercised under section 126 of the Electricity Act to raise a provisional assessment, serve it in the manner prescribed to the consumer, and the consumer will be entitled to file objection, and within 30 days, my Lord, he shall pass the final assessment order and serve the consumer within that period, my Lord. My Lord, law is 165 regulation says, and 126(3) also says that the final assessment order is to be passed and served on the consumer within 30 days from the date of provisional assessment order. So far this case is concerned, my Lord, they did not pass the final assessment order. 4 months lapsed, my Lord. Then in of regulation 165, my Lord, you have a glance, my Lord, that since no final assessment order was passed within that date period, my Lord, the demand provisional assessment order attained the finality, being null and void, my Lord. You Lord may see regulation 165. You Lord may see this. Yeah. Lord, I may be permitted.
OERC distribution condition of
OERC distribution
2019.
Another copy I am providing. OERC distribution conditions of the supply code 2019. My Lord, 161 says how the assessment will be done in the prescribed format. Then, my Lord, 165 says, my Lord, when a person on whom the provisional assessment order has been served shall be entitled to file objection, if any, against the provisional assessment before the assessing officer within 7 days, who shall, after affording a reasonable opportunity of hearing to such person, pass a final order of assessment within 30 days from the date of service of such order of a provisional assessment of electricity charges payable by such person. During the hearing, the assessing officer shall give due consideration to the facts submitted by the consumer and pass speaking final order as to whether the case of unauthorized use of electricity is established or not. The order shall contain the detailed inspection submission in detailed inspection report, submissions made by the consumer in his written reply, and oral submissions during the hearing, and reasons for acceptance or rejection of the same. If no final order is passed and served on the person whose electricity consumption has been provisionally assessed within 30 days of service of provisional assessment order, then such order shall be null and void.
Yes.
At this juncture, your lordship may have a glance to this provisional assessment order which they have the demand notice, my lord, that they have served by the annexure 1 series at page 13, my lords, you have a glance. My lords, in this notice, my lord, annexure 1 series page 13, running page 13, my lord, on the bottom concluding line, you are therefore called upon to show cause within 7 days from the date of receipt of this notice. My lord, this notice is dated 7/10/2022. Well, it was served on 14/10/2022, on which date the 7 days was elapsed, my lord. Then, my lord, on bottom, my lord, Bandiram Malik has received it on our watchman has received it on 14/10/2022. Then, my lord, lordship may see when it was received on 14/10/2022, my lord, the consumer filed his objection on 21/10/2022, my lord. And, my lord, soon after this, my lord, filing, no final assessment order was passed, no opportunity of hearing was given.
What is your objection?
My lord, annexure 2, page 18, my lord.
Yes.
It was filed, my lord, on 21/10/2022, and, my lord, thereafter no opportunity of hearing was given, no personal hearing was done, and, my lord, when nothing was done, the petitioner waited for 4 months, my lord, and thereafter, my lord, he approached the grievance redressal court in view of this provision, stating that since no final assessment order was passed, which was made provisionally, or demand notice was made, that has become null and void in view of the such provision. So, my lord, the prayer is, my lord, at page, this petition filed before GRF is annexure 3, my lord. Lords may have a glance to page 20. My prayer is, my lord, at page 24, running page 24, to withdraw the amount as per regulation 165 of OERC distribution conditions supply code 2019, to reconnect the power supply to my complaint, to the complainant, to avoid unnecessary delay. When my power supply was disconnected since long, I prayed for restoration of power supply and to withdraw this amount which has become null and void in view of a particular provision of law. Then, my lord, the GRF, my lord, without registering the complaint, my lord, this complaint was filed on 6/1/2023. Till that time, nothing has been sought by the consumer, my lord. Regarding withdrawal of assessment amount, annexure 4, lordship may have a glance to page 26. GRF हमको intimate कले regarding withdrawal of assessment amount or reconnaissance of power supply. So, लिखिले sir, the OP has issued final assessment order on 135 of the 2000 Act on 2/11/22. Copy of the same has been attached herewith. Regarding withdrawal of the final assessment amount, this forum is not authorized to pass any order for any relief. You may approach the appropriate appellate authority under 122nd, my lord. My lord, this notice, my lord, was given to me on 11/1/2023, my lord, after 4 months, my lord. Then, my lord, when the GRF refused, my lord, as against the order of a GRF, my lord, I approached the ombudsman of electricity by filing, my lord, this is the final assessment order. They have said that they have passed it on 2/11/2023-22, but fact remains that was not served to me on despite lapse of 4 months, my lord. My lord, then I approached the ombudsman, praying for same relief, my lord. Agreed with the non-acceptance of my complaint before the GRF, I approached the ombudsman, praying the same relief, withdraw the assessment amount, and reconnect the power supply, my lord. The ombudsman, my lord, while accepting registering the complaint as CR case number 15/23, my lord, he passed an interim order on 17/2/23. Yeah, you deposit 25,000, 25 lakhs, power supply will be restored. Lord, I deposited by obtaining a loan, my lord. I deposited the amount since my unit was in dark since last 5 to 10 months, my lord. I deposited the amount and obtained power supply, my lord. My lord, it was passed on 17/2/23 interim order. By interim order, I availed, deposited 25 lakhs and availed power supply. Then, my lord, the OP appeared and filed the objection, stating that they have passed the final assessment order, but nowhere they have stated that we have served it on the consumer on such and such date. Then, my lord, when final
But the fact remains that there is a final order today.
they says that they have passed the final assessment order. They have, fraudulently they have done it. What if they have passed, what prevented them not to serve it on the consumer when the law demands that, my lord? Law demands that it should be served, passed, and a rescind order is to be.
Provisional assessment order ହେଲା ପରେ ତାଙ୍କୁ regional ପରେ ତାକୁ consider କରିକିନି pass କରିବା the final law. That has not been done, but behind the back of the pieces. What say?
I ଟିକେ କହିଦେବି sir. Sorry ଆସିଲା. Then, my lord, when the final case was finally heard, my lord, the ombudsman has said that we lack jurisdiction to entertain this type of complaint. Because it is under 126.
127 appeal has to be filed.
Appeal was required to be filed. There was no need to entertain my complaint and direct me to deposit 25 lakhs, and soon thereafter they discontinued the power supply, though this order was passed by the ombudsman.
What prejudice should cause you if you file a 227, 127?
Milord, they have raised an illegal demand, Milord. The assessing officer is not a.
No, that is on merit. But
merit, I am in Bodan, 1 crore 24 lakhs more घर factory सब बिकिदेल हबनी आज्ञा मते गोटे लार्ज फोल्ड को नै जाई करी मोर डिमांड टा 1 year पछुर तक पसी देछन कोटी 24 लाख आज्ञा मु 25 लाख लोन करके देली मोर सर्वाइव करबी लोन टा सुझीबी कोन बर्तमान मो लाइन टा इन डार and 126 मिलर जतले 165 कहूची it will be null and void मिलर for is the necessity to approach the appeal by facing the financial burden, my lord. And my lord, ombudsman, this is the ombudsman order, and against that I am come. My submission is, my lord, the person who has verified the premises is not the assessing officer. Some outsiders have verified the premises, and law is well settled that the EP assessing officer has not verified the premises and doesn't know the extent of unauthorized use. He cannot pass any order under any of the provisions of law. First, he is not the assessing, he is being the assessing officer of 126. He has not followed due provision of law. He was not present during the verification. So he cannot raise a demand against me without seeing the nature of unauthorized use.
The ombudsman
was for to set aside the demand, to treat the demand as a null and void in view of regulation 165.
Where is that application?
Milord, that page 23, Lord Simesi, running page 23. Milord, I have stated, it starts from 22. The person on whom the provisional assessment order has been served shall be entitled to file objection. That regulation 165, what I have placed before my lord. He has quoted this.
No, this is between GRF. That's
GRF, Milord, same Milord. GRF complaint is, Milord, at page.
That is annexure 5.
Milord. Lord Simesi.
Annexure 5.
Annexure. No,
Milord,
GRF complaint is annexure 3, Milord.
No,
ombudsman annexure 5, Milord. 42.5 रे होची anchor power, ombudsman GRF रो, and 42.6 रे होची ombudsman को power representation. If the consumer will be dissatisfied or agreed with the order of GRF, then he may move the ombudsman. And in view of a division bench decision of this honorable court, Milord, the GRF has power. You also may see this. I am placing.
The entire argument is that this particular provision 165 of the 2019 code has not been followed. That goes to the root of the matter. Right. Because it shows that once you serve a provisional assessment order, right, what is thereafter is to be done. Right. A reasonable opportunity of hearing is to be given, and that is he has to be afforded opportunity also to file whatever he wants to file, and then can only this, considering the written reply, oral submission and hearing, then you can file the final order. He is totally not aware about you all on a sudden said that final order has been passed, but on what basis when he has filed the complaint and the challenging that provisional order, it is your duty to show that when and in how you have complied with this particular provision.
Go to the application also.
ଆପଣ ସିନା ବନ୍ଦ ହେଲେ ସରିବ, ଆପଣ ତ ଆପଣ ଆଜି this is the final hearing. We are considering so far as issuance of notice is concerned. And if you think that is a final hearing, then notice is to be issued. He has to obtain instruction in the matter. So yes, what do you?
There are two things, Manoj. After the ombudsman order was passed, the facts which is not there in the brief, I've obtained instruction, prima facie instruction, Manoj. He filed a review. Before the ombudsman. Now that review has been disposed of on the basing upon a memo. That memo says that since the petitioner wants to file an appeal before the appropriate authority, the review is to be disposed of. That document is not there with your lordships.
Then you consider to file a
appeal. When the main case is disposed of, I withdraw the appeal, that memo, review petition, my lord. There is no power of review.
ଆପଣ ବର୍ତ୍ତମାନ କେବେ ସେଟା ଫାଇଲ କଲେ ରିଭ୍ୟୁ?
It is disposal final.
Prior to filing of the writ petition.
No.
Why you have not brought it in the writ petition? Review file kale, review re एमती गोटे application देले.
Review
that's the reason we are asking specific question. See, ultimately what the GRI and ombudsman says that you resort to 127 appeal. What prejudice is caused? And you might have realized after that thing, and therefore you filed the memo saying that okay, I'll file
review petition, my lord. Why he's a
you say that I'll file appeal.
He has filed a review, my lord. My lord, when the review is filed by that time, my lord, their main order has been passed. My lord, suppose the review is withdrawn.
No question of suppose.
My lord, review dismiss ho by withdraw ho, sir. Main order stands, my lord.
No, you should amend it. We cannot say that.
My lord, I will file.
Jaha bhi heichi.
Sir,
it should be brought on record.
Sir, I will bring it on record, my lord.
Why the other side will point it out?
No, sir. It has
the writ petition has been filed by the petitioner, so and so, challenging the order dated so and so, dekhi lik do, hai na? During course of
2/4/2024 and the writ
this writ petition was filed
27/11/25.
During course of hearing, Mr. Lalit Kumar Maharana, Land Council, who is appearing for the opposite party, submits that against the order dated so and so passed by the ombudsman, the petitioner filed a review petition, which is this is the review petition number.
Well, what the ombudsman does is it quotes the same number but entertains petition.
Review petition filed, and thereafter an application was filed for withdrawal of such petition, praying for leave to file appeal before the appropriate authority. And accordingly, the review petition was allowed to be withdrawn by the order dated 2/4/2024. The copy of the order has been filed, which is taken on record. Mr. Das, I just stop. He further submits that nothing has been mentioned in the writ petition, which was filed on 28th November 2025, regarding the filing of the review petition by the petitioner and withdrawal of such petition to file the appeal. Mr. Das, Land Council, appearing for the petitioner, doesn't dispute that such thing as has been pointed out by the Land Council for the opposite party has happened, and that the same has not been reflected in the writ petition, which according to Mr. Das has been advocacy omitted, and he wants to amend the writ petition to incorporate in that respect and list this matter on such and such date. If an interim application is filed for amendment of the writ petition, the same shall be listed with the IA. The Warden Council for the petitioner also filed the relevant provision under section 160 under 165 of 2019. What do you say about
distribution conditions?
What do you say? It is a section or something like that?
Regulation 165.
Regulation 165, which is taken on paper.
Not that document decision which I refer may be refunded to you.
Yes. You file your application, interim application, and make a mention, we list it. Yes. Next.
Item 13.
Madam, we have filed the application under Annex 4 before the District Magistrate Khurda, Collector and District Magistrate Khurda under the Surface Act, Section 14 of the Surface Act. My application is pending, my lord, 24/9/2024, my lord. And the similar cases in WPC number 10628 of 2025.
You want let us status or instruction around to it is pending before whom? District Magistrate.
District Magistrate.
So you are to obtain instruction.
My lord, similar order past 10628 batch cases, my lord.
कौन है कौन order रही
This court also passed similar order.
Similar order माने कौन हो?
10628 by 2025.
अरे copy दे दियो that list.
Where is that order?
Similar order passed.
What similar matter I am also having. If you also permits, I can give that order. It is there if I phone have.
Copy के बाहर कर.
1819 रे I'm there before your lordship.
नहीं कौन order ଦେଇଥିଲା कौन?
ଆଜ୍ଞା ଆପଣ ସେଥିରେ କହିଥିଲେ କି district magistrate କୁ CJM କୁ ସମସ୍ତଙ୍କୁ କି ଯଦି defect ଥିବ defect statutory period ଭିତରେ they must dispose of as per circular.
What is suppose it has been might have been passed to know, that is why we are keeping it to day after tomorrow. You
after knowing the status only.
Knowing the status, we can pass that order. There is no problem in passing. And please bring out that order.
Yes, madam, I have to go by.
अरे खाली मोबाइल देखिले कोना मोबाइल देखिले. Petition has been filed by the petitioner for a direction opposite party number 1 to sponsor. We found out that the petitioner has approached the district magistrate Khurda under section 14(1) of the Surface Act for taking physical possession of the secured asset, and the application was filed on 24/9/2024, but no action has been taken. Land Council for the state has received the copy of the petition and seeks some time to know certain about the status of such application. Place this matter day after tomorrow. Yes. Next.
Item 14.
Day after tomorrow, bar. Yes, Mr. Sahoo.
Your Lordship, I'm appearing on behalf of Mr. Nalinkanta Sahu for the petitioner, Your Lordship.
What do you want?
We wanted a disposal of the essay, Your Lordship, secretary.
Essay?
It is filed 16th July 2025, Your Lordship.
25 essay, why will dispose? The old cases are pending there.
The difficulty, Your Lordship, is that there are repeated auction sale notices having been
Who are
issued,
you?
Your Lordship.
Who has approved the
I have approached the TRT. Your
I
Lordship.
means what?
The petitioner, the owner of the borrower has.
Borrower. So pleadings are complete.
No, Your Lordship.
Then how can it be direction? And you have to move an application there. If the pleadings are complete and it's a 2025 matter, why old matters are pending and there is regular, the land council are bringing that old matters are there and he is unable to dispose of, and will direct a 2021, then plot plate will open and everybody will come here.
Merely because you could afford to come to High Court, so therefore you will get preference. The people, those who can't afford, they'll have to wait.
And pleadings are not complete.
If I may, my lords, on
yeah.
Let's hear what has happened. The petitioner has purchased the property. When he purchased the property,
we are not going. Your simple prayer is the simple.
Because the reason is why we have moved this honorable court is that because we filed interim applications for interim relief in those matters. Because the repeatedly auction sale notices, as and when the auction sale notices are being floated, we are filing the IA before the DRT. Those are not being taken up. That is the difficulty. Otherwise, my IA is pending. Every day they are in every 15 to 20 days they are floating auction notices.
Where is the order sheet?
At annex order sheet.
That you don't want that essay should be declared.
Only my interim, interim application should be considered.
IA should be declared.
Yes.
What is those IA numbers?
If your lordship sees.
No.
I region 1812.
Yes, madam.
Which one is the last I?
Madam, I'll just.
এই দিটা না আর কিছু আছে
Dita, madam. That is at page 13.
We move that application, we'll passing the order letter. This writ petition has been filed by so and so with a prayer, so and so. After going through the averments taken in the interim of the writ petition and in view of the nature of relief sought for, we dispose of the writ petition that if any application has been filed by the petitioner for early disposal of the interim application, aforesaid interim application, the same shall be considered by the DRT in accordance with DRT, and it is made clear that at an earliest, and it is made clear that we have not expressed any.
Sorry, my lord, in this matter, today the DRT proceeding is there before the DRT. The Sonalika Mahapato with the petitioner. She the neither borrower nor guarantor nor mortgager.
Whatever we are not taking any
But she has purchased a mortgaged property.
କଣ ଆମେ କଣ କହିଲୁ ଆମେ ତ କିଛି କହୁନୁ interim application ସେ ଗୋଟେ application ଦେବେ expeditiously disposal କରିବେ ତାକୁ ସେ consider କରିବେ ଆଉ ତ କିଛି we are not expressing any opinion on the merits of the interim application. So also the Suna Sahu, the land council party. ଆପଣ କାହା ପାଇଁ appear କରୁଛନ୍ତି Mr. Sahu?
No, on behalf of Union Bank of India.
अच्छा opposite party number
mortgage property.
हाँ 2 and 3. ଆପଣଙ୍କର वकालतनामा ଦିଅନ୍ତୁ ଦିଅନ୍ତୁ ତାହେଲେ ଲେଖା ହବ ନହେଲେ
Yes, I will.
ବାକି ରହିଲା ପହର ଦିନକୁ
Item number 10, my lord. I could not be there at the time of call. Item 10. Passover matter.
Passover ରହିଛି ପହର ଦିନ ଆସିବ
My lord, item 18 and 19, it is similar to that matter of direction to Chief Judicial Magistrate.
କେତେ ନମ୍ବର କହୁଛନ୍ତି
item number 18 and 19
ଆର ଡିଫେକ୍ଟ ଅଛି ପରା
defect ଆଜ୍ଞା ସେ କହୁଛନ୍ତି କାହିଁ CGM କୁ ପକ୍ଷ କଲି CGM କୁ କାହିଁ ପକ୍ଷ କଲି but in this case my lord CGM ପକ୍ଷ ଥିଲା ଆପଣ ଯେତେବେଳେ order ବି କରିଛନ୍ତି that number I am giving section 14 ରେ my lord he has special
ଏଇଟା ନା instruction ନେଇ ଆସନ୍ତି ଏଟା
ନାଇଁ ସେଟା 15 ତାରିଖ ଅଛି ଆଜ୍ଞା
କୋଉଟା
18 19 ର CGM କଟକର so I only pray ପରଦିନ ଆସୁ ରିଟ୍ ପିଟିସନ ନମ୍ବରିଂ ହେଇକି
18 and 19 you want it on
Friday
all right ସବୁ ତ ଆସିବ ନା
ନାଇଁ ନମ୍ବରିଂ ହେଇକି ଆଜ୍ଞା ସେଟା ଯୋଉ D number ଦେଇଛନ୍ତି your lordship judgment I am holding your lordship has allowed it the writ application chief judicial magistrate ସେଥିରେ ପକ୍ଷ ହେଇଛନ୍ତି the only defect there saying କି ମୁଁ କାହିଁ CGM କୁ ପକ୍ଷ କଲି ମୁଁ ଜଜମେଣ୍ଟ ବି ଦେଲି ସେ ଶୁଣିଲେନି କହିଲେ ନାଇଁ କୋର୍ଟ କରିବେ ଆମେ ଆଜ୍ଞା କରିପାରିବୁ ମୁଁ କହିଲି ଅନରେବଲ କୋର୍ଟ କୁ ଦିଅନ୍ତୁ ଅନରେବଲ କୋର୍ଟ କର ନିଜ
ଏଇଟା କଣ ଦେଖି ଡିଫେକ୍ଟ ନମ୍ବର 3
ଆଜ୍ଞା ଦିଟା ଆଜ୍ଞା ସେମ୍
ଲେଖା ହେଇଛି ଡିଫେକ୍ଟ ନମ୍ବର 3 କାଇଁ under the remarks कौन अरे कहीं डिफेक्ट नहीं airport number not tally in the petition annexure 1 as for index
मतलब say defect I have already removed the only thing it was
not mentioned so and so
all that has been removed
one not made a party एगुड़ा कहूची और defect अपन जोड़ा कहउचनी CM को काई पक्ष कले
ये मत ये सेही जो defect गुड़ा initially थिला I had removed those defects and the deputy registrar himself told me that Mr. Counsel your defect is why you have put CGM as a party ordinarily CGM cannot be made a party I told that is the ordinary law civil court criminal court arbitrator are not made party
item number 18 though in the remarks column some defects have been pointed out
removed my lord
Mr. Mishra land council submits that he has already removed the defects as pointed out the registry shall verify and if the defects are removed then the matter be placed on 12th of December 2025 for admission. Yes, next.
Obliged.
Item number 30.
Same order in
19.
19 also.
Obliged.
Item number 30, I had mentioned in the morning, your lordships consider fixing a time to take it up because it's since 2023 sales certificate ପଇସା ଦେଇକିରି ପାଉନି
ଅଛନ୍ତି
ଆଜ୍ଞା actually Mr. B.N. Udgata is there.
Mr. Udgata, Mr. Mukherjee mention କରିଥିଲେ ଆମେ କହିଥିଲୁ admission fresh admission ସରିଲେ ନବୁ ବୋଲି ତ କେବେ ସେ କହୁଛନ୍ତି ନବା ପାଇଁ ଆପଣ କୁହନ୍ତୁ ଗୋଟେ time fix up କରିଦବା
Let's say fix. I have no objection.
ତ ମଣ୍ଡେରେ ରଖିଦଉ ମଣ୍ଡେ 12ଟା ବେଳକୁ ନବା
ଆଜ୍ଞା
item 33
କେତେ
ମିଳିଲା
ନବା sir? Instead of Monday, can it be Wednesday? Monday have
Wednesday କେତେ number item?
Item 30.
30 କରିଦିଅନ୍ତୁ on the consensus of both the parties. Matter will be taken up on 17th December 2025 at 12 o'clock.
item 33 मिला item 33 item 33 मिला
Item number 15. My main contestant is TPCODL.
ପରଦିନ ଆସିବ ଆଜି କଣ ପାଇଁ
No, 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 they have not filed a counter yet.
In item 15, I am for the opposite pattern 7. But I have deposited about 13 lakhs.
ଆମେ ଆଜ୍ଞା ଭିତରୁ ଯାଉନି ଆମେ ବର୍ତ୍ତମାନ
Let it come on Friday. Let it come on Friday, my lord.
we are all bringing all these matters on Friday.
Monday,
item number 17 permitted to withdraw.
item 33
Day after tomorrow. Additional affidavit which was given by the officer.
Madam, you all these matters will come and you mention it on Friday.
item 33 मिला item 33 my miscase for giving power supply and the matter was at length मिला your lordship at the admission stage
After tomorrow. Yes, sir.
Item 20.
Serial number 3388 of 2025 is an application for interim bail on the ground that the father of the appellant expired on 5/12/2025. So, the petitioner is the only son, and in order to perform the obsequious ceremony of his deceased father, the presence of the petitioner is very much necessary. The Land Council for the state has produced the written instruction dated 9/12/2025 of IAC Satyavadi Police Station, Puri, which also states that the father of the petition is expired and the obsequious ceremony will be held on 14/12/2025. Considering the awareness taken in the interim application hearing Land Council for the respective parties and the written instruction received, we are inclined to release the petitioner to interim bail for a period of 2 weeks on the date of release. Matter is fixed on such and such date. He will produce the surrender certificate. Yes.
Item 39, sub-item 3,
Yeah.
and item 51 for interim bail minutes were awaiting instructions. May be taken up before your lordship.
Yes.
And item 23, my lords, there the bail is till today.
So you are teaching that as call the matter serious.
Item number 49 about a similar pair. The matter has called for a report from the concerned state authority, and the petition has been taken on several occasions to the MKCC hospital. But don't
call the matter.
Understood?
Pardon to make a mention.
Supplemented daily, second up, item number 1.
What is this appeal for?
802.
Order need call for the prior court report. Theoretical and yes, corporate. Yes.
Item 2.
Report was called for, madam, regarding welding of the regarding apprehension of the accused.
Yes, Mishra.
In this case, that charge sheet investigation from the charge sheet file warrant has been issued. The entire CDI called is affidavit and
No, he was there in that Viju Patnaik open air ashram Jamujari. Now, whether this man was gone on parole or furlough, whatever it may be, or escaped, which category he falls?
escaped.
Escaped.
What steps you have taken?
What steps you have taken?
The 2018 FIR was logged with the Chandaka police station.
Yeah.
Investigation was conducted. In the meantime, charge sheet has been filed, and his arrest could not be made that by virtue of for prayer, warrant of arrest has been issued on 28/2025. That is in the affidavit.
So by simply issuing the warrant of arrest and in such type of matter where a life convict has escaped from your Pune jail, that would subserve the purpose or something else has to be done. Your DG Prisons has appeared on that day and stated that we are taking every step to apprehend all those persons. How many persons escaped?
3, madam. There are 3, madam.
About 60.
One person permitted this case, 2% absconded and changed
No, not in this case. Totally from that.
66 cases.
59 here, 32 from only Jammu. 15 was parole or imprisonment, and 17 escaped.
No, parole to olga kotha. Eti apanଙ୍କର ମାନେ ଏସ୍କେପ୍ କରି ଯାଇଛନ୍ତି 17ଟା, ଯୋଉମାନେ ପ୍ୟାରୋଲେ ଯାଇ ଫେରି ନାହାନ୍ତି ଦ୍ୟାଟ୍ ଇଜ ଏ ଡିଫରେଣ୍ଟ କେସ୍।
17.
ଏଠି ଆପଣଙ୍କର 17ଟା ଲୋକ ସେଇ ବିଜୁ ପଟ୍ଟନାୟକ ଓପନ୍ ଏୟାର ଆଶ୍ରମରୁ ଯାଇଛନ୍ତି and they are all life convicts. So that is why we asked you to hire.
That's it. The detailed report has been received. If there is some other to detail affidavit is to be filed. What steps has been taken?
File that DG prison should file an affidavit. It's not that anybody XYZ.
Your answer will not.
When the
we
matter
issued
was
warrant.
taken up on
Warrant,
26th
obviously warrant will be issued.
2025, and after appearance of the DG of prisons to virtual mode and having interaction, then we came to know that from the detailed list of convicts furnished to us, we came to know that from Biju Patnaik Open Air Ashram, Jamuchari, 17 persons have escaped, oblique absconded, including the appellant Munsi Bue, alias Mansi.
मंगवा दो, 1 घंटा लगेगा और क्या?
We asked the Learned Council,
आधा 1 घंटा लग जाएगा ना।
the state to apprise this court about the status, the recapture of the appellant. Learned Council for the state stated that one FIR was lost after the escape in the year 2018, and charge sheet has been submitted in the said case, and warrant of arrest has been issued against the appellant. No documentary evidence has been produced before us.
Is there?
No, we are not producing any document, we are writing. Let an affidavit be filed by the DG of prisons personally as to what steps have been taken, not only in this case, but also in other cases where the life convicts have escaped, oblique absconded from Biju Patnaik Open Air Ashram, Jamujari, to recapture them. All the details in each case should be given serially, and it should also be indicated
This one?
if any action has been taken against erring official
2.4.
who might be
मंगवा दो।
negligent or responsible, for which the life convicts have escaped, oblique absconded.
फुल कर दो।
Matter be placed on 22nd of December 2025.
Gravy
Next.
Item 3.
Right.
only one.
It visuals. Here on the last occasion, I filed the bail application. IA 415 for 2025. The appellant is in custody since more than 14 years. Since 1/7/2011, he is in custody.
His custody certificate indicates it to be 12 years and 11 months. It was of which year? What is your instruction, Mr.? 18. Total custody ajan lekha is 11/11/2025. 11/11/2025. So it is 12 years, Mr.
Not 14 years.
Not 14 years, because perhaps during that 1 year period that
No, during the time of exemption, the I was stated that since 1/7/2011 is in custody.
no, he was not there in from 2011 or 12 to that 2013, that COVID period, perhaps he was.
Maybe.
So that is the reason why.
Paragraph 3 has admitted that he is in custody since consent.
And you have never filed bail application earlier.
No, ma'am.
And what
Bail
is the
criminal
case?
appeal, I have no connection with that appellant.
Case of direct evidence or
That the case is based on circumstantial evidence. Only with regards to
How many deceased are there?
One. The wife is the deceased and this present petitioner is the husband.
Or you are escaping holding a cotari.
Right. That
which
is the only
in-
circumstance against this present appellant.
And previous quarrel is there.
Previous quarrel is there.
And you gave recovery to the weapon of offense.
No, so far that part is concerned, Pedal 12, 13, they are declared hostile. They have not corroborated it.
Para 7 of impugn judgment.
My lord, Para 7 is based on
Base 6.
Circumstances.
But Mr. Mahanti, that man is in custody for more than 12 years. And Lekhun, or the learned counsel for the petitioner, learned counsel for the state, learned counsel for the petitioner submits that the petitioner is in judicial custody for more than 12 years. And it's a case based on circumstantial evidence. And there are good chances of success in the appeal. And balance of convenience is in his favor. And since there is no chance of early hearing, even though the paper book has been prepared, bail application may be favorably considered. Learned counsel for the state opposed the prayer for bail and pointed out the circumstances which are available on record against the petitioner, which is discussed in the impugn judgment from paragraph number 7 onwards. Considering the submission made by the learned counsel for the respective party, nature of evidence available, absence of any direct evidence, period of detention of the petitioner in judicial custody, absence of any chance of pardon, we are inclined to release the petitioner on bail, stay realization of fine. And this copy be communicated to the so-and-so jail superintendent, so also to the Muller and trial court. Yes, next, and copy of the order be handed over to the land council for the state. And bail allowed, stay fine. Yes, next.
Item 4.
You have the state file the conduct and a custody certificate.
Yes, Mr. Unfinished.
October 18 2 লাখ 37 জোর কন্ডাক্ট ইজ গুড অ্যাজ নো অর্থস
18 2 মাস
2417
হ্যাঁ
18.5 2417 ଅଛି 8.5 ବର୍ଷ
ହଁ ଇଏ ଆଗୁ ରିଜେକ୍ଟ ହେଇଥିଲା କି
ନାଇଁ ନାଇଁ ଫାଷ୍ଟ
ସିଙ୍ଗଲ ମର୍ଡର
eyewitness
my lord P9 and 19
doctor
my lord
Postmortem doctor 16.
Come to one eyewitness.
P3, your lordship, P3 evidence is there, my lord. Position copy. Position copy. Yes, jail criminal को अपन आने ना. Then I will take extract from the.
Pen drive and Acha, the learning council for the state has produced the custody certificate. So also conduct certificate of the petitioner from the jail superintendent, which are taken on record. The learning council for the state submits that he has not received the deposition copies of the witnesses. ଆମେ order କରିଥିଲୁ let the registry supply the deposition copy so and so in his pen drive. तो ଆପଣଙ୍କ ଦାୟିତ୍ୱ ହେଉଛି pen drive ରେ ନେବେ. The order, a specific order has been passed on 7/11/2025, directing the registry to supply such copies to the Rand State Council in his pen drive. Rand Council for the state submits that he will receive the deposition copies during course of the day. Put up this matter on 17th of December 2025. Next.
Item 5.
Complaint facility.
What complaint facility?
Because the last order, the lordship that 28/11/2025. They've served the written instruction.
CPIS is also regarding the criminal antecedent and they have also the connected JCR. He has also handed over the copy of the instruction to the Land Council for the appellants who seek some time to obtain instruction. So what is your instruction?
Malasni, so far as the present appellant number 1, there is no criminal antecedent except this case.
No,
more the item Malasni JCRL 80 of 2024. Two appellants are there.
Yeah.
Appellant number 1 is concerned, there is no antecedent except this case. And the 2 is concerned, that has been reflected in one case, but that was already been acquitted all the accused persons. That has been judgment I have annexed. So petitioner name, but the appellant's name is not there, but other accused persons have been acquitted.
So you have received the copy? The Land Council for the appellant has filed the comprehensive affidavit of the appellant number 1 as well as appellant number 2, which have taken on record. Copy has been served on the Land Council for the state in court today, who took some time to go through this and put up this matter on 17th of December 2025. Next. As a week as you were the JCRL number 105 of 2024.
Item 6.
Under the present appellate in custody since more than 11 years. And from the scene date of arrest is 31/12/13. More than 11 years custody and custody certificate is at flag D. And earlier the appellant is never come for bail.
That is nothing is there that custody certificate.
Flag D, my lord.
Flag B.
Flag B.
अच्छा 11 वर्ष 6 मास 22 दिन.
My lord.
That was 22/7/2025. तामने आउ 4 मास खंड गलानी. तो हमको आसीबो. It may be 11 years 10 months.
And one more thing, my lord, I received one certificate from regarding my.
What certificate?
That work, skill work.
Good conduct.
What is the age of the petitioner?
Age of the petitioner matter at the time of judgment is aged about 45 at the time of judgment.
The case of double murder.
Double murder.
And eyewitnesses are there.
Eyewitnesses are there.
So who are the eyewitnesses?
Eyewitnesses
PW is 1, 3, 4, 5, 6, and 10.
2, 3, 5, 6. PW7 is the informant, my lord.
1, 3.
1, 2, 3, 5, 6.
Doctor?
Dr. PW 16 and PW 17.
4 is also injured in the incident. PW 4.
Injured witness.
Yes.
So 4 number secured.
PW.
What is your name?
Baya Swing.
Baya.
Baya.
Three accused persons so and so Baya Swine came with swords with
knife
male persons, where the male persons were taking bath. They first assaulted the father-in-law Gola Swine, then to Raji Swine with swords. We are on the other side of the pond, and on seeing us, Maya Swine went and tried to save. In the process, the left hand was severe. The right hand was almost severe, but not cut off fully. We called the police.
Attico Swine assaulted the mother of that deceased.
PW 16. Chopwound ଅଛି ଗୁଡାଏ chopwound ଅଛି
But weapon of offense not produced before doctor for opinion.
We are not on February 2004. Next.
Item 7.
Yes, Mr. Jaffrullah.
It's a case of P76 and this victim was turned hostile. Your lordship, report was called for regarding the child.
Order dated 7/11/2025.
7/11 ପୂର୍ବରୁ ରଖିଥିଲେ ହଁ 7/11 26 ତାରିଖ ରଖିଥିଲେ କହିଲେ 8 ବର୍ଷ ରହିଯିବ
victim as well as child.
Yes, remain 8 ବର୍ଷ ରହିଯିବ complete ହେଇଯିବ 26 ତାରିଖ.
We asked for status of the.
That report was submitted already. The child has already been adopted and the victim has already married to other person. That report was thereafter your lordship stated that, expressed that you remain on 26 plus 8 ବର୍ଷ complete ହେଇଯିବ. Victim PW2 turned hostile.
Where is your custody certificate?
Custody certificate ବି ଆସିଥିଲା.
On what basis you say that you have already undergone 8 years of sentence?
8 years, right? 26/11/2017
26/11 ସେ ଯୋଉ ପିରିୟଡରେ ପୁରା ଯାଉଥିଲେ ସେଟା ଜଣା ପଡୁନି ସେମିତି ଏ ଯୋଉ କୋଭିଡ ପିରିୟଡରେ ସବୁ ପଳେଇ ଯାଉଥିଲା.
Custody certificate, sir.
Yes.
Custody certificate was called for.
Yes.
How judgment
फॉर्म बी
23/11/2017
from 23/11/2017 to 22/3/2021, thereafter 1/7/2021 and 4/8/2021.
4/6/21 ଯଦି କୁହାଯିବ ବି ଏଇଟା ହେଇଗଲା ଆପଣଙ୍କର
23/11/2017 custody since 23/11/2017
8 years ହୋଇଛି।
ଆଜ୍ଞା 8 years that is lordship fixed to 26 କହିଥିଲା ସେ ପାଇଁ ମୁଁ ନଥିଲି ସେଦିନ କହିଲେ let you remain for 8 years complete victim turn hostile and the report was also called for child has already been given adoption to other person and the victim is already married to other person
Victim କେତେ ନମ୍ବର section?
PW2
PW15
PW2 turn hostile
So he supported the prosecution case, but a part he was, but
no,
then he admitted everything.
then
I've
in
stated.
cross examination also para 6 and para 9
Yes, what do you say, Mr.
She was a minor. Date of birth was
17 years as on the date of the
25/2003.
Obviously, at that point of time, they were. IA number 99 of 2025 is an application for bail. Current counsel for the petition submits that the petition is in judicial custody for more than 8 years. He submits that the victim who has been examined as PW has not fully supported the prosecution case for which she has been declared hostile. And the report has been called for from IIC Laikara police station, which shows that the victim has already got married and the petitioner had given birth to a female child.
Victim.
Sorry, the victim had delivered a female child, and that has been adopted by somebody.
Yes.
And that child has been adopted. And therefore, the bail application may be favorably considered. Land Council for the state placed the report of the IIC Laikara police station dated 25/9/2025. So also the evidence of the victim, bracket PW
2.
The victim has stated that she eloped with the appellant with her own sweet will. Further stated that the appellant had kept sexual relationship with her
of prisoner petitions at flag B and C millets, we are instructed to appear for the appellants millets. Flag B and C millets. We have also filed
Prisoner's petition has been filed for engagement of Mr. Ronak Kumar Raut. Wakalatnama filed.
Yes.
Your associate.
Yes.
You are Mr. Raut. All right. Here is the prisoner's petition filed by the appellants. Appellants. And both of them have filed.
Yes, Lord.
For engagement of Mr. Ronak Kumar Raut as their counsel. Mr. Raut has also filed Wakalatnama of the appellants, which is accepted. The name of Mr. Karunakar Das shall not be reflected in the cause list henceforth.
My lords, Market D is the custody certificate millets, which shows that appellants have been in custody more than 8 years and 3 months. They have filed an IA number 381/2025 millets, but I am handicapped because I do not have the copies of depositions with me.
What do you want?
Lords, I want the deposition copy maybe.
If your pen drive will allow.
Yes, yes.
Land counsel Mr. Rao submits that he is not having the deposition copies. Let the registry supply him the deposition copy in his pen drive. Aji nehi janto.
Tomorrow, by tomorrow.
Tomorrow could assume. Aji to hadi achi record ta achi na. To take the pen drive apna kahar ote nehi janto taru nehi jive copy kari. Na? Yes, next.
I will also call.
State council will permit for them.
There are two other applications arising out of the same.
No, ठीक है जी, ये bail application था जोटा, that will be considered next week. But you receive the deposition copies. Paperwork, in fact, has not been prepared. So, yes, next week कर दूँ.
70.
Yes, sir.
Item 9.
Mr. Samal.
My lord, on behalf of Mr. G. Samal, kindly be this matter taken up after vacation.
What is your name, madam?
Susri Sangita Naik.
So and so appearing for Mr. Gangadhar Samal, 6 for an adjournment after winter holidays. List this matter. State reason.
Item 10.
That for bail of appellant number.
How many appellants, Mr. Panda?
3.
What about 1 and 2?
One is on bail. He is also on bail.
Can you tell us the order when they were granted bail? 1 and 2.
Sridhar Das was released on bail by order dated 6/4/2015.
Just a minute. A1 hella 6/4/2016. What about A2?
This honorable court held that that order shall not be treated.
Which one?
The 6/4/2016 order.
No, we are not on that. We just want to know that whether the appellant number 2 has been released on bail or not. Appellant number 3 of bail reject ହେଇଥିଲା 6/12/2019 ରେ.
Appellant 2 was granted bail on order dated 30th of September 2014.
2014.
Just
Order
your
number?
lordship and Justice Prasad.
30th of
September
2014.
This case 1067 of 2000. Interim bail was granted.
Just a minute. That was for a limited period.
Yes, Lord.
Thereafter, another order is
Thereafter, your lordship has granted
6/4/2016.
Appellant number 2.
Yes, my lord. Abhinna
yes,
alleged
6
Abhimanyu
4
Das.
2004.
ଏଟାରେ ପୁରା ହେଇଛି. So what about the appellant number 1?
Appellant 1 was granted bail in the first instance.
କେବେ date କେବେ?
6/4/2016.
Export
ସେଟା
appellant number 2 କହୁଛନ୍ତି. appellant number 1 ନା ହଉଛି ଶ୍ରୀଧର ଦାସ.
ଶ୍ରୀଧର ଦାସ ହେଇଛି ଆଜ୍ଞା ଜେଲରେ ହେଇଛି 2014 ରେ. First point out here.
18/12/2013.
18/12/13 मिसके 1147
So how many years you are in custody?
Custody certificate is there.
14 years. କେବେ କରେ ଏଟା?
14 ବର୍ଷ 4 ମାସ 18 ଦିନ as on 24/10/25.
ଦି ଜଣ ଯାଇଛନ୍ତି. ଏଟା ଫାଇଲ ହେଇଛି appellant number 3 ପାଇଁ. Are the land council for the petition land council? local लोग ना बाहर?
Local.
Local.
Are the land council for the petition land council for the state? This is an application for bail of appellant number 3. Dhaneshwar Das. Anybody is appearing for the informant, Mr. Samir Mishra?
Yes.
Anything you want to say?
No.
Mr. Panda, there are number of applications for appellant number 3.
Yes, Lord.
Which one you not press you? Because 2025 application टाକୁ ରଖୁଛୁ ବାକି ତା ପୁରୁଣା ଟାକୁ not press କର.
2985 of 25 to
ଏଟାକୁ ଯୋଉ 704 of 2017 ଟାକୁ not press କରିଦେବେ ହେଲା. ଆଉ ବର୍ତ୍ତମାନ ଏଇ order ଟା pass କରିବେ IN number 2985 of 2025. This is an application for bail of plan number 3 so and so. Land council for this petitioner submits that the petitioner is in judicial custody for more than 14 years, which should be evident from the custody certificate of the superintendent district jail Puri,
filed as annexure A to the Act.
which has been annexed,
Filed as annexure A to the Act.
which has been annexed to the interim application as annexure A hyphen. He submits that the other two appellants, that is appellant number 1 and appellant number 2, are already on bail. The land council for the eyewitnesses submit that there are
informant himself.
Case of single murder or double?
Single.
There are eyewitnesses to the occurrence, and the version of the eyewitness also get corroboration from the medical evidence. Considering the submission made by the land council for the respective parties, nature of evidence available and medical evidence, while not inclining to release the petitioner on bail and merit but taking into account his period of detention in judicial custody for more than 14 years, we are inclined to release him on interim bail for a period of 3 months. बाकी डेट को एक्सेप्ट कर देवे सरेंडर सर्टिफिकेट देगा and had informant counsel to सुन लेवल लिख दो. Yes, next.
Item 11.
During the fact that the appellants have been in custody more than 12 years, Lordship on 14/5/2025 admitted the appellants to interim bail for 3 months. In the meantime, they have surrendered, but I have applied for the certified copies, but I have not received it. The Lordship may call it on the 19th, by that.
Mr. Raut Land Council submits that after availing the interim bail period, as per order dated 14/5/2025, both the appellants were granted bail.
Yes, Lordship.
Both the appellants were granted bail, interim bail for a period of 3 months. And he has instruction that after availing the same, they have surrendered.
Yes, Lordship.
But he seeks some time to produce the surrender certificate. अच्छा, आउट बेल एप्लीकेशन फाइल कर दी है.
Yes, sir.
अच्छा, stop. List this matter on IA number liquid. It appears that the Land Council for the petitioner has filed another application for bail, which is registered as IA number 3208 of 2025. Copy upon receipt for Janda.
I'm sorry.
And give it the Land Council.
I just saw.
Sought the copy of the interim application. Put of this matter on 19th of December 2025. Land Council for the state shall obtain instruction regarding the conduct of the petition while on interim bail, and Land Council for the appellant or petitioner shall produce the surrender certificate. Yes, next.
What is the role attributed to you and difference? Appellant number 2.
Custody, only custody gain down. I will.
No. The role attributed. Appellant number 2
direct allegation. Appellant number 2 तो एटा होची 1 और 3.
हां 2 कौन दीजिए.
हां 2 को दिया था. 2. How do you segregate the case of?
That's what I'm asking. What is the role attributed to?
Role manager
Two.
अरे तीन ही जन appellant में थी. We have granted interim bail for 3 months to that appellant number 2. 2 months. So is the case distinguishable or they stand on a similar footing? No, ma'am. There is no similar. कहूना थी कौन
There is allegation in
eyewitness रे देखा तो कौन distinction?
PW2 my lord, page 95.
ये PW2 रहा था. अच्छा से appellant number 2 ना आटा कौन करते?
Appellant 2 my lord, Sanjukta Naik.
Her lady term.
Number 2 is my lord.
Para 8 my lord. I also followed them in my presence. Kalu Naik told to Mami.
Paragraph पढ़ुचंदी?
Paragraph 8 my lord. Mami, but Mami replied that I will not go. Why you have come?
अरे appellant number 2 ना कौन संयुक्ता कौन कहले?
नहीं PW2 my lord.
appellant number बुझी पार नहीं थी.
My lord.
तीन ही जनो appellant.
My lord.
ठीक तो?
My lord.
appellant number 2 को हमें बेल देइछु 3 मास ପାଇଁ.
My lord.
हला ता ना होची कारू alias कालिया नायक.
नारायण नायक.
हाँ हाँ नारायण नायक व कालिया नायक जा.
काली वाले काली.
तो ये ऑर्डर के भी थी था बेल.
Order my lord.
Order my lord.
24/11/25.
11/2025.
22 24/11/25.
25.
तो वो भी Yes, shows the distinctive feature between this. तो आपण पढुथिले PW2 eyewitness statement.
Para 8 my lord.
Para 8 हाँ.
I also followed them in my presence. Kalu Naik told to Mami, Chaliasa, but Mami replied that I will not go. Why you have come to take me? Thereafter, Nirakara Naik tried to assault my son Amara, but Mami told her that ତାକୁ ମାରିବା ପୂର୍ବରୁ ମୋତେ ଆଗ ମାର and shown her hand. Thereafter, Kalu Naik brought out one kuradi kept in my house, but Budha Naik took the same from his hand and assaulted my son by means of said kuradi. And Nirakar Naik assaulted to Mami by means of khanda.
Then Kalu is not given any blow.
Kalu is not.
Kalu Naik खाली
assistant.
कुराड़ी टा आनी की नहीं था बड़े ही. मारिची तक बुढ़ा.
बुढ़ा नहीं कर निराकर.
बुढ़ा जोन को मारची निराकर. So that rule is different. याको ये बॉयस कितने माने करते?
Question number 38.
Young सब बुढ़ा तो young वर्षन. 29, 31. Period of detention तो है ला किसी criminal antecedent अच्छी.
Yes.
हाँ. He has not been called for.
माने सबुथरे गोटे ऑर्डर करिया पड़ो जा कोन तीनटा जिंस कुहाउसी सबुथरे आनिया पई आजि गोटे काली गोटे कोन माने
बेल मैटर तीनटा जिंस पचार जाउ ताको पचार नहीं कहबे ना आपण कहबा आपण तरफ
माल
आपण तरफ भी कोन किछि एवरी क्वेश्चन इज आस्क्ड योर आंसरिंग
आइए नंबर 3263 of 2025 is an application for bail filed by appellant number 1 and 3, namely Nirakara Naik and Bija
Durga alias Budha Naik.
Durga alias Budha Naik. From the custody certificate, it appears that both the appellants have remained in custody for more than 10 years. And it further appears that appellant number 2, Kalu alias Kalia alias Narayana Naik, has been directed to be released on bail, interim bail, for a period of 3 months, as per order dated 24/11/2025. The London Council for the State, however, submitted that placing the evidence of PW2, the eyewitness to the occurrence, that the role attributed against the appellant number 2 is completely different than appellant number 1 and 3. However, he seeks for an adjournment to obtain the criminal antecedents, instruction relating to the criminal antecedents of both these appellants, so also their jail conduct. Put up this matter on 17/12/2025. ଆପଣଙ୍କୁ ଗୋଟେ ସାଇକ୍ଲୋଷ୍ଟାଇଲ ଫର୍ମାଟ କରନ୍ତୁ ଯେକୌଣସି ବେଲ୍ ଆପ୍ଲିକେସନରେ କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ, ଜେଲ୍ କଣ୍ଡକ୍ଟ ଆଉ କ୍ରିମିନାଲ ଆଣ୍ଟିସିଡେଣ୍ଟ, ଆଉ ଯୋଉଥିରେ ଇଣ୍ଟ୍ରିମ୍ ବେଲ୍ ଯାଇଛନ୍ତି 3 ମାସ ପାଇଁ ପୁଣି ଆଉ ଗୋଟେ ବେଲ୍ ଆପ୍ଲିକେସନ ଦଉଛନ୍ତି ତା ଦେହରେ ତାର କଣ୍ଡକ୍ଟ ଡ୍ୟୁରିଂ ଇଣ୍ଟ୍ରିମ୍ ବେଲ୍, ଏଇ କଥା ଡେଲି ଅର୍ଡର ପାସ୍ ହଉଛି ତାକୁ. Yes, next.
Item 18.
Yes, Mishra. Item 8, Padman Bag.
Yes, my lord.
Kudia Lokoye.
Man of Rayagada. All the appellants have been convicted on section 395 for 10 years and a 364A for imprisonment of life in. It is alleged that they demanded 5 lakhs and kidnapped the victim. Thereafter, they trapped the victim at Muniguda police station, and the victim proceeded to Muniguda. They dropped the victim at Muniguda railway police station, and thereafter, victim proceeded to Muniguda police station.
The bail application was rejected on 2/9/24.
Rejected. Successive applications, and they are virtually inside custody as custody certificate 6, my lord. Almost 9 years now.
2, 3, and 11 eyewitnesses.
Eyewitnesses are there. One is PW2 and
We want 2 things because your bail application has been rejected on merit and year back. So we want a custody certificate. Number 2 hochi apankara criminal antecedent and jail conduct. एवढा नहीं कि ना सुनते एटा रा उसे जो कनेक्टेड अपील उड़ा है ना तो किधर CRL number 1, this is an application for the interim bail 1. Land Council for the state seeks some time to produce the custody certificate, criminal antecedent, as well as the jail conduct of the appellant, as well as the appellants in the connected appeals. That is CRL number 1. So list this matter on. Yes, next.
Item 19.
Yes. Here, my fiction as a language scheme, jail custody from 21/12.
Report कौन उड़ा
The interim bail has surrender कर दिए.
has been sent after expiry of the interim bail period.
Surrender.
Conduct कौन आसिला पुणी आउट रिन्यू केते मास ପାଇଁ ଯାଇଥିଲେ
से 3 मास पुणी ଯାଇଥିଲେ
ଆସିନି ଲେଖନ୍ତୁ
ମଗେଇଥିଲେ ନା
ନା
ଅର୍ଡର କଲା ପରେ ଫାଷ୍ଟ ଟାଇମ୍
ସେ ଅର୍ଡର ନ କଲା ମାନେ ଆସିବେନି। ସେ ଅର୍ଡରରେ ଲେଖା ହଉଛି ସବୁ ଯୋଉ ଦିଆ ହଉଛି ଯେତେବେଳେ ଇଣ୍ଟ୍ରିମ୍ ବେଲ୍ ସେତେବେଳେ ନିଶ୍ଚୟ ଲେଖା ହେଇଥିବ କୋଉ ଅର୍ଡରରେ ଯାଇଥିଲା ଆପଣ
27/11/2024 ଆଉ ଥରେ ଇଣ୍ଟରିମ୍ ବେଲରେ ତିନି ସପ୍ତାହ ପାଇଁ ଯାଇଥିଲି ଫାଦର ବେଲ୍ ଯାଇଥିଲି ରାଇଟ୍ ଟାଇମରେ ସବୁ ସରେଣ୍ଡର।
The IA number 1647 of 2025. This is an application for bail. Mr. Hon'Ble and counsel appearing for the appellant submits that the petitioner last time has been directed to be released on interim bail by order dated 27/11/2024 for a period of 3 months. But you did not surrender perhaps. 27/11/2024 କେବେ surrender କଲେ?
27/11 I have given the surrender certificate.
Surrender on 3/3/2025. Flag E. Acha. And he surrendered before the land and trial court after having the interim bail period. Land Council for the state has received the copy of the interim application. And he seeks some time to obtain instruction relating to the conduct of the petitioner while on interim bail 17/12/2025. ସବୁ ଗୁଡାକ ଅର୍ଡର ଆଜି କମ୍ପ୍ଲାଏ ହବ ଲେଖିବେ ତାପରେ ଘରକୁ ଯିବେ।
Custody certificate and antecedents.
କଷ୍ଟଡି ସାର୍ଟିଫିକେଟ ଲେଖା ହେଇଥିଲା
ଲେଖା
ହଉଛି ଗତ ଥର ପୁରା ଲେଖା ହେଇଥିଲା ଫେଲ ଦିଆ ହେଇଥିଲା
8 ବର୍ଷ
ଯା ଆଉ କଣ next
Item 20.
The petitioner has been convicted.
Custody certificate ମଗାଇଥିଲା criminal antecedent and jail conduct ତିନିଟା ଜିନିଷ ମଗାଏ। କଷ୍ଟଡି କେତେ ଅଛି?
He's in custody since 21/8/2015.
No, ସେ ଆଣିଛନ୍ତି। ଆଚ୍ଛା 3/7/5/5 କେତେ ହଉଛି?
10 years 3 months 5 days
10 years ଆଚ୍ଛା ବାକି found that he was involved in Patnagarh PS case number present case अच्छा present case बाकी jail conduct and behavior of the satisfactory अच्छा maintain respectful and cooperative demeanor अच्छा এটা ସେଟା local man ଲୋକ ନା ବାହାର ଲୋକ?
Local.
Single murder na multiple murder?
Single year. He says some people dragged her wife, and thereafter he orally reported and police discovered. But he has been made accused saying that
eyewitness ଅଛନ୍ତି?
Circumstantial evidence.
Are Mr. Samit Kumar Mishra, land senior advocate, appearing for the appellant. As for the order dated 19/9/2025, the Land and Council for the state has produced the custody certificate of the petitioner, which shows that the petitioner is in judicial custody for more than 10 years. More than 10 years. More than 10 years. And he has further produced the report from IAC, Patnagar Police Station, which shows that there is no other criminal antecedent. The conduct certificate has been produced from the superintendent, District Jail Balangir, which shows that the conduct and behavior of the petitioner is satisfactory and he has maintained a respectful and cooperative demeanor with both fellow inmates and staff members. And no misconduct or misbehavior has been reported during his incarceration period in the jail. The reports are taken on record. Mr. Mishra submits that it's a case based on circumstantial evidence and there is no chance of early hearing of the matter and paper book has also not been prepared. Land Council state opposed the prayer for bill considering the submission made by the Land Council for the respective parties. Absence of any direct evidence, nature of circumstantial evidence on record, period of detention of the petitioner in judicial custody, absence of chance of early hearing, we are inclined to the petition on bail allowed. Obliged.
Item 21.
Given that earlier bail was rejected on 14/9/2023.
14/9/2023 bail rejected.
The IA has been filed for bail in allowed to take instruction of custody certificate in jail control.
अच्छा IA number 531 अच्छा ये अच्छा prisoners petition आदर मिली file कर दीजिए वकालत नाम Mr. Sahoo अच्छा left on a prisoners petition has been received for engagement of Mr. C.R. Sahoo as his advocate. Single appellant though? Mr. Sahoo has filed wakalatnama which is accepted. The names of the earlier engaged counsel shall not be reflected in the cause list henceforth. Stop. IA number 2531 of 2025. This is an application for bail. The Land and Council for the state takes some time to produce those three documents: custody certificate, jail conduct, and criminal antecedent. Matter will be listed on 17/12/2025. Yes, next.
One prayer, my lord. I
Yes.
allow to take the drawing declaration exhibit 6 lordships.
Land Council for the appellant said you they submit that is not having the copy of the dying declaration which has been exhibited in the trial court as exhibit 6. Let the registry supply the same in the pen drive of the appellant. ଅଛି ଏଟା ଦେଇଦେବା ଗୋଟେ ପେଜ ଏଇ ଶୁଣୁଛ ନା ନାଇଁ ଆগে କଣ କିଛି ବୁଝୁଛ ନା କୋର୍ଟରେ ବସିଛ ନା ଉପରକୁ ନଉଛ? Yes. Next.
Item 22.
On the appellant's filing number, they are information. This is second out journey. Alleged was disposed of. I think with the objection not inclined at this stage. Three no they are 24 and no weapon, nothing was used. And only the
3/9/2024
I-8/488
eyewitness ବର୍ତ୍ତମାନ ଆପଣଙ୍କର ପିରିୟଡ ଆସିଗଲାଣି ସବୁ ଆଣିଲେ କି ନେଇ ଆସନ୍ତୁ ସେଇ ତିନିଟା ସାର୍ଟିଫିକେଟ ନେଇ ଆସନ୍ତୁ ସତର୍କ କରିବାକୁ ଚାହୁଁଛନ୍ତି.
This bail application is for whom?
all the appellants, all were also on bail.
Five of them.
Again, no weapon, nothing has been used.
17/12/2025. Yes, next.
Item 24.
Yes, Mr. Panda, it is your case.
Item 23.
23.
I appear in criminal appeal for 23 of 2000.
The appeal would have found
Your Lordship may look at the last order that your Lordship passed. One 2025. This
Where is the surrender certificate?
My lords, against that order of your lordships,
Yes.
we moved the Honorable Apex Court, my lords.
Yes.
And I have filed a copy of the order of the Honorable Apex Court by a memo dated 8/12/2025.
Where is that?
That memo has not come on record. So, it's there, Neil. Yes. Page 271, the order of the appeals court. At page 272 of this year. Last it. Nope. The Honorable Apex Court, my lords, by this order has extended that interim bail till today, my lords. The next date of
That is in one case.
I think there were two appellants, my lords. Bablu alias Niyaranjan Das alias Patnaik. And the other appellant was the appellant here, that is Suli alias Nigamananda Jena.
CRLA has been filed by one appellant.
Yes.
So obviously the SLP was also filed by
my lords.
That is Nihar Ranjan Das, it's somebody else.
Nihar Ranjan Das is criminal appeal 758. With SLP criminal 19666.
No, ଆମେ case wise ଦବୁ ଆମେ ଏ order ଟା ଯୋଉ pass କରିଥିଲୁ Uli alias Nigamananda Jena
ଆଜ୍ଞା
ତା ପାଇଁ
ସେଟା with ପରା ଆସିଛି ସେଇ order ରେ with
ଅଛି 19666 19666 yes
ଆଜ୍ଞା SLP criminal 19666 of 2025
19666 ଏଇଟା ହଉଛି କାହାର
ଏଟା ଟୁଲିଆ alias ନିଗମାନନ୍ଦ
ଆଚ୍ଛା ତାହେଲେ ଏଇଟା ହେଲା ଟୁଲିଆର ଯୋଉଟା ହଉଛି CRLA
423
ଏଇଟା ଏକ୍ସଟେନସନ ଆଉ ବାକି ରହିଲା ବାବଲୁ ଟା କୋଉଟା
ସେଟା ହେଲା 758
758
ସେଟାର ଗୋଟେ ଫ୍ରେଶ ଏଫଆଇଆର ଇନ ବିଟୱିନ୍
ରୁହନ୍ତୁ
ମେରିଟ ଅରବିନ୍ଦ
CRLA 758 ହଁ ଏଇଟା ହେଲା ଏକ୍ସଟେନସନ ହେଇଯାଇଛି ଆଉ ବାକି ଯୋଉଗୁଡାକର ଅର୍ଡର କରିଥିଲୁ
what I am presuming from this order itself is that since their lordships have said that the applications are listed before the High Court for consideration of the prayer of the petitioners. Maybe, my lords, I think it would not be inequitable if your lordship holds that all of them have been allowed to continue on bail till today.
There is a specific order on that.
Lords, one other thing your lordship will bear in
Some
mind.
of them have decided to go there. Others were satisfied with her order. So that order is to be
My
complied
lords,
with.
one is in custody. One of them is in custody out of the four.
Who?
He was not on bail.
CRLA number 1141 of 2020. 114.
Last item.
Just a minute. CRLA.
Madhya.
1141 of 2023. देखिए जरा order टा बाहर करी.
Sir, well,
He's already in custody.
he's in, no, he's in custody in this appeal.
That's right. No problem. There is no question of surrendering.
हमें लिखिनु ना what steps have been taken. हमें तादेर भी चाहिए तो लो.
He has taken interim bail for a while and then surrender.
There is only,
Lordship Director order is
there is only one thing I would ask your lordships to bear in mind.
Please interim bail has surrendered or not, and if not, what steps have been. So this man has already surrendered. A report be called for report as still. With regard to Sham to intimate that Swansu was released on interim bail passed in front. Subsequently, the offense surrendered and 4 years in after completion of the charge. It likhi diyon to age.
But he has earlier also he has not gone to Supreme Court.
Report
that Madhya.
Look, CRLA number 1141 of 2023. On 1/12/2025, we called for a report from the Land Trial Court as to whether the appellant, after availing the interim bail period.
Can I interrupt your lordship for a moment?
Yes.
Report is
So far as the date is as that part is concerned, my lords, on the 6th itself, I have filed a memo in the trial court, bringing to the trial court's notice the order of the apex court. And the trial court has posted the matter to 11th, awaiting your lordship's order.
No, he has reported that he has surrendered.
No, in so far as Madhya is concerned.
Yes, my lord. Yes,
we are passing the order in Madhya first.
We are passing the order in Madhya.
Then
1141 of 23. And कौन लिख ले? Whether the petitioner, whether the appellant has surrendered or not. The Learning Trial Court has submitted the report, which is dated T12/2025, wherein it is mentioned that the appellant surrendered before the court on 23/2025 on completion of interim bail period and committed to Circle Jail Chodwar, Cuttack. Okay. বাকি এটা 11 ର ଗଲା এটা ସରେଣ୍ଡର ହେଇଗଲା ତାପରେ ଏଇଟାରେ ସୁପ୍ରିମ କୋର୍ଟ ବେଲ ଦେଇଛନ୍ତି ଆମର 423 ଅଫ 2023 ରେ ଆଉ ବେଲ ଦେଇଛନ୍ତି 758 ଅଫ 2023 ରେ ବେଲ ଆଚ୍ଛା what about 629 of 2023?
Mr. Mahapath.
My lord, admittedly, he has not approved the Honorable Apex Court.
What order we have passed?
It is a common order.
I know, separate.
So you are supposed to file the surrender certificate.
No, my lord, my lord. In view of the order passed by this Honorable.
Yes. What happened?
That he has not approved the Honorable Apex Court,
yes,
like other two, but the implication of the order means that it has been extended. In the whole process, maybe it is a wrong advice. On the 6th itself, my lord.
Comply that order. You have to file the surrender certificate. Then only can your bail application. If you have not gone there, we cannot presume that the order has been passed in your favor.
To that extent, I do accept.
Yes.
But what happened is just I am addressing this Honorable Court. He appeared before the ground court below And since the orders were
The
produced,
problem is you have not even moved an application for recalling that order which we passed last time. That order is staying on the record.
yes.
If we moved an application saying that in connected matter SLP is allowed, so please extend it, then we could have done it. So moto we can't recall that order.
Yes, since he has not surrendered, what steps you have taken? Yes,
instruction I have taken.
What instruction?
She appeared, my lord, she appeared before the
Trial court.
court on 6th. But
Now it is listed on 11th.
On 6th, what happened before there? The court, after going through the order of the Honorable Apex Court, allowed them to continue on the previous. Well, it is a wrong conception of the trial
How
court.
can the trial court will ask them to continue in view of our order when there is no order? Then it is contemptuous. If you made a submission, file an affidavit, we can ask for a report and we will initiate proceeding against the trial court. How he has
How
done
you
it.
can give the benefit of that order to you?
Order has been passed in favor of X, he will apply on his own motion at again in favor of Y. And he has the audacity to defy our order even though appellant is surrendering, and will allow him to continue on bail. Yes, what steps you have taken?
On T12, we have sought for instruction from the T12. We have sought for instruction. There was a direction for to surrender by sex.
What your SP and Commissioner of Police has done?
That letter we have issued, but instruction not received. I refer some other.
Ask him to appear on Friday.
Monday.
Criminal Appeal number 629 of 2023. As per the order dated 1/12/2025, we directed the appellant to surrender by 6th of December 2025. And the surrender certificate was also directed to be produced for consideration of the bail application. It was specifically observed in that order that if the appellant failed to surrender by 6th of December 2025, the Superintendent of Police of the Commissioner of Police, Bhubaneswar and Cuttack shall ensure that the appellant is arrested and produced before the London Trial Court. And thereafter, the London Trial Court shall remand the petitioner to judicial custody and report to this court. No report has been received from the trial court, and it is stated by the London Counsel for the appellant, Mr. Mahapatra, the London Senior Advocate, that the appellant has not has come to the court on 6/12/2025 and he wanted to surrender. But since the order was passed in favor of the co-accused persons by the Honorable Supreme Court, the London Trial Court did not accept surrender and keep the case to 11th of 12/2025. Let a report be called for from the London Trial Court regarding the submission which has been made by the London Senior Advocate. Stop. The Superintendent of Police shall appear in person before this court on 12th of December 2025. And no, it is only for him. And produce the as to file an affidavit as to why our order dated 1/12/2025 has not been complied with. Yes, now you call the other items. Yes.
I may submit one of that DCP Cuttack, not the DCP Cuttack.
DCP Cuttack. Yes.
I may beg to say, in view of this ambiguity, a interim application was filed before this Honorable Court, which in the board today, that is IA number 3412 of 25. In that application, it was prayer was made to allow him to continue on interim bail.
Which was?
That 3412 of 25.
In which item?
629.
Sub item 2.
6 to 9. Interim application number 34112 of 2025. This will be considered on 12th of December 2025. Yes, Mr.
May
Pandey.
15. 12th, I will not.
No, this is so far as this application, we are segregating now the case. 6 to 9 we are considering on 12th. Your case you can place it today. 4 to 3 of 2020. Yes.
4 to 3, my lords.
Yes.
I was convicted by the learned trial court
Yes.
under section 302Z with 120B of the ICC. Sentences of imprisonment for life and fine of rupees 20,000. In default, arise for 1 year. On the date of the alleged incident, my lords, I was in custody.
No, just a minute. Mr. State Counsel, the bail order was set aside by the Honorable Supreme Court, taking into account the law laid down in the case of Atul Tripathi. And there, the position is that opportunity is to be given to the state to file objection. This is number one. If the public prosecutor does not file the objection in writing, the appellate court shall in its order specify that no objection had been filed despite opportunity being granted by the court. Number three, the court shall judiciously consider all the relevant factors, whether specified in the objection or not, like gravity of the offense, nature of the crime, age, criminal antecedent of the convict, impact on public confidence in court. In the light of the legal provision, it is submitted that no volume of argument is required to establish that the impugned order did not satisfy the consideration in the light of the legal position. Atul case opportunity was given to the state to file objection, if any in writing. However, the order should reveal that after availing the opportunity, no objection in writing was filed, though the prosecutor entered appearance. The court concerned to specifically record in the order that despite giving opportunity to file objection in writing, no objection was filed on behalf of the state. Then the court, in the event of such objection not being filed, to consider judiciously all the relevant factors, including the gravity of the offense, so on. If the order is analyzed, then it would be revealed the absolute absence of such consideration required. So now, since this is the reason why the order of this court was set aside by the Honorable Supreme Court, and it has been remanded for fresh adjudication, and we are considering the interim application, that is, which is that interim application?
That is IA number 926 of 2023.
So, have you filed any objection?
Objection as flag E.
Flag E.
And another objection.
Just a minute. Put it upon. Objection at flag E. Okay.
Informant also I have filed.
Just a minute. IA number 926 of 2023 bail application, and state objection which is flag E.
Flag E.
Objection dated है कुछ
State objection flag E ना अच्छा बाकी इंफॉर्मेंट पर ऑब्जेक्शन कितने हैं
That is at flag D.
Yes, Mr. Pandey, you can please.
Yes. Your Lordship. I have filed a rejoinder also, my lords, to the objections.
Rejoinder filed.
Now, so far as the earlier SLP is concerned, my lord, and the directions in Atul Tripathi. Atul Tripathi, my lord, if that direction has is be considered, my lords, then every order that has been passed will have to be
No,
set.
don't go to that. Don't go there. You come to your merits of the case.
On merits, I am submitting, my lord.
Yes.
Now, so far as I am concerned, my lord,
yes.
The criminal appeal was filed, my lords, after I was convicted. And your lordship may look at the first order suit. Order dated 19/5/2023.
This appellant, Priya,
yes,
he was on bail during trial.
No, he was in custody throughout, despite a direction of the apex court.
When he was taken into custody?
He was taken into custody on 30th of April 2016.
30th of April 2016.
Aye.
Not released on bail.
This court granted him bail.
No, during trial.
Yes, during trial, this court granted him bail. The order was stayed in the Honorable Apex Court.
Okay.
Then the Honorable Apex Court set aside that order, saying that on the prayer of the informant that some witnesses were the eyewitnesses who were to be examined within a limited period of time. The court gave liberty that if those witnesses are not examined.
In fact, he has not been released.
No, he has not been.
So then this conviction, the judgment was passed on 7/4/23.
Miles.
Okay. Thereafter, the order was passed by this court, bail order.
Miles.
On what date?
Bail order is on 9/10/2023.
9/10/2023. Bail order passed. Okay.
Before that,
yes,
I'll ask your lordship to kindly look at order dated 19/5/2023. The first order when the matter was listed. Your lordship will see that the state is represented by learned counsel.
Yes.
Then the matter was again listed on my prayer in the bail application on 13/9/2023. On that date also the state was represented by counsel.
Yes.
Then, my lords, on the date of the hearing of the bail application, the state was represented by learned state counsel and my learned friend Mr. Ratha appeared for the informant.
Right.
Now, Mr. Ratha is aggrieved by this order of bail. He approaches the Supreme Court saying that Atul Tripathi has not been followed.
Okay.
Now, my respectful submission, my lords, is that since copies were served on the state, my lords, at the time of filing of the application, and since Mr. Ratha had appeared and copies had been served on him, my lords, both of them did not file written objections as mandated in Atul Tripathi. And after hearing their oral objections, my lords, this court granted bail on 9/10/2023.
No written objection
were filed either by the state or by the informants.
Oral objection, that has also been noted down.
Yes, oral objections are noted, my lords.
Yes, then
even Atul Tripathi was not cited before this court, my lords.
That's all right. They have not filed any. Admittedly, they have not filed any written objection.
Exactly.
Yes.
Now, so far as conviction of this appellant is concerned, this appellant is not convicted under section 30. His conviction is under 120B of the penal code. Because admittedly, it is the prosecution case also, my lords, that I was not present at this court. And I was in jail custody as per the evidence of the IO. On the date of incident also, I was in jail custody. The evidence of the IO is also that his investigation does not reveal that while I was in jail custody, I have met with the other co-accused persons at any time. This evidence is also brought out from the evidence of the cross-examination of the IO.
So, your involvement in the case is criminal conspiracy?
Yes.
While in custody?
Yes.
While in custody, okay.
Then, my lords,
yes.
After the apex court set aside the order and remanded the matter back, my lords, objections were filed both by the state as well as by the informant. Now, even at that stage also, they did not file objections on the date the application was directed to be reheard by this court. When the matter was remanded and the date was fixed to, I believe, 15th of May 2024, my lords, no written objections were ready either by the state or by the informant, my lords. So therefore, what your lordship may kindly look at, order dated 15/5/2020.
What they have stated in the objection. Let us say that they have filed the objection.
Yes.
What they have stated.
Now, if your lordship will look at objection by the state, my lords, at paragraph 2, he says that the trial court has assessed all evidence and prima facie concluded that appellant is guilty. Then, at paragraph 4, he says, the state says that in this case there are 7 eyewitnesses, PWs 1, 2, 5, 6, 7, 11, and 12. All these eyewitnesses have categorically and briefly stated against all the accused persons, including the present appellant, for the commission of the alleged crime, and their testimony has been clearly and cogently corroborated by the testimony of the evidence of the IO PW21. And defense has not even given a word, shaken the evidence of all eyewitnesses. This is erroneous, my lords, because none of these eyewitnesses have stated about my presence. And the IO admits that I was in custody. Then, my lords, they say that the doctor's evidence corroborates the evidence of the eyewitnesses and I have not taken any stand to shake the evidence of the doctor. I was not required to do that. Then he says, weapon of offense, that is MOs 2 and 3, have been seized at the instance of the co-accused, where PW14 is cited as a witness to recovery under 27, and he has supported the prosecution case against all the accused. Lords, how can that be possible? A witness to recovery under section 27, he can only support at best, my lords, the recovery that has been made. Or if we stretch his evidence, my lords, then if he speaks about the confession that is made, it will tantamount to nothing but an extrajudicial confession at the worst. So nowhere, my lords, my complicity comes. Then para 7, the state writes that it is proved by the informant PW20 that prior to the occurrence there was business rivalry between the brothers, and accordingly in 2013 FIR also lodged against Tulia alias Nigamajana and Chogala Molli. Apart from these, just few days before the occurrence, a long poster was stuck on the wall of the informant's house, where it has been written that the accused will kill the informant and his family members if informant will stand on the way of their brother Tulia alias Nigamajana. Now to that my reply is, admittedly the informant has a liquor business, my lords. No evidence has been laid that I had any liquor business. I am a super class contractor, my lords, and all along, my lords, my work is executing contract. So I have no business rivalry because I don't have the business which he has. Neither he has laid evidence that I have liquor business, nor he has laid evidence that he also is a contractor who executes projects. So the question of business rivalry is false. Then regarding that poster that has been stuck, the evidence of PW15 totally negates it. The case that was registered with regard to that poster, I am not an accused there, and my complicity was not found. And the IO Biridi PS, who was examined as PW15, he has negated that evidence.
Okay, Mr. Panda, you come to paragraph 11.
Now, before that, your lordship may kindly look at paragraph 9. Paragraph 9, the state says like this. Sixth line, other accused persons are the instigators, and incident had taken place at the instance of accused Tulia alias Nigamananda and Madhya alias Madhav Das. Lords, I can't understand this sentence with my limited knowledge of English. The entire prosecution case is that I was the person who, while in custody, made arrangements and asked the co-accused to commit the crime. But the state says that it is the other accused who are the instigators, and the incident has taken place at my instance. Out of conspiracy. No evidence of conspiracy or prior meeting of minds is there. Now, paragraph 11, my lords, I admit, yes, all these cases are there. In all these cases, I am on bail. NSS were quashed by this court long ago. And so far as criminal antecedents are concerned, my lords, my only submission before your lordship
Where is your rejoinder? Let us see. Reply affidavit.
Yes.
What about this criminal antecedent you have stated in your reply affidavit?
In my reply affidavit, I have filed a reply to the objection of the informant.
That we have got it.
Laggy. Yes. Now your lordship may kindly see.
You come to state that particular
Yes,
paragraph, criminal antecedent.
Paragraph H of my reply.
Paragraph
H.
uh-huh.
That in reply to the averments at paragraph 11 of the objection, it is submitted that the deponent has not been convicted in any of the criminal cases registered against him as on date, and his detention under NSA were quashed by this honorable court, and he is on bail without any allegations of having abused his liberty while on bail. With NSS were of the year of the 80s and 90s, Millers, 1980s and 1990s. As far as I remember, there were 4 NSS, 3 were quashed by this court. The 4th one, Millers, the board rejected it.
That's all. Yes, Mr.
And I am complying with all Miller's conditions that your lordships have imposed.
Your custody period would be now 9 years, 9.5 years. If you have not been, you are released on bail.
I was custody period will be 7.5 years, Miller's.
Because that period you are granted bail.
Yes.
And you are released from custody, and then you come to surrender the court. So the bail order was passed on 9/10/23.
My lord.
And you have not yet surrendered, means it is to be calculated up to that period. So 30/4/2016 ରୁ ଆମେ ଯଦି calculate କରିବୁ ତାହେଲେ ଏଟା ହବ 7 ବର୍ଷ, maybe 5 months, something like that.
7.5 years.
Yes, Mr. State.
Then your lordship may kindly look at another thing, your lordship.
Yeah.
The informant's objection. That is most vital.
Informant.
The informant in his objection, Millers, has alleged
antecedent paragraph number.
Their entire allegations relates to the antecedents, Millers. Most of these antecedents, Millers, this present informant is the informant in probably 3 or 4 cases, Millers. All his affairs are to the same extent. As in this case, he was not present at the spot. He says, I was in Calcutta, I got information about the incident. And I was told that the persons who came and fired at my brother, they took the name of the appellant here, the present petitioner. Similarly, my lords, he has given 3 or 4 FIRs saying that either my liquor shop was bombed or some other incident has happened when I was not there. But people who came and did that, They say that we are doing it at the instance of Tulia alias Nigaran. And in my objection, my lords, to your lordship, may kindly look at paragraph B of my objection. Objection to the informant's appeal. I have stated that in reply to the averments at paragraph 3 of the objection, it is admitted that this deponent has been shown as an accused in several cases, but there is no conviction of this deponent on record. And in view of total lack of evidence regarding deponent's presence at the spot on the date of incident, and PW21, the IO has admitted in his evidence that deponent was in jail custody on the date of the incident. Deponent has not been convicted as on date in any of the criminal cases where has been named as an accused, and his detention orders under NSA have all been quashed by this honorable court.
Yes, sir.
Then, your lordship may see at paragraph C, I have stated deponent was never put to any TI parade for being identified by PW2 as has been ever. They say that I have been identified. There is no TI parade in which I have been put, nor I am in any way connected with any alleged threats to the family of PW2, nor that is reflected in the impugned judgment.
Okay, Mr. Panda, when by virtue of the order of this court dated 9/10/2023,
yes,
when this petitioner was released on bail,
I'll find out from the PCI.
Have you got any, Mr. Rotho? Immediately. Acha, is there any report after that date against the petitioner?
No, that report has come.
After 9/10/23?
Yes, your lordship has called for reports.
Where is that report?
That is when the matter was heard by the earlier division bench, reports were called, and therefore it was adjourned, my lords.
Oh, no, we just want to see that once again.
After hearing of the matter was closed, my lords, the matter was again listed before this court, my lords. My lords may look at order dated 8/10/2024.
Oh, that is by the other bench.
Yes, by the other bench, your lordship may first look at order dated 6/9. 6/9/24 Heard learned counsel for petitioner, learned counsel for state, as well as learned senior counsel for informant. Hearing of the appeal along with criminal appeals number such and such being concluded, order is reserved.
Okay.
Then, my lords may look at the next order. 8/10/24. Paragraph 2 taku dekho. While perusing the materials placed for addressing the rival submissions in passing the order, this court feels it apposite to take into account the conduct of the appellant during all these periods when he has been enjoying liberty in view of the order passed by us, which is continuing to be in force and now required to be passed afresh, giving a relook, keeping in view the order of the Honorable Apex Court, as also conduct while inside jail. In that view of the matter, the government advocate is directed to obtain a report from the proper quarter to the above effect by the next date of listing.
Kon asila report? Kon asila?
That report will not available. I may have some short date.
No question of short date. The bail is till today. We are to pass the order today.
That report is
not seen the report order of the Honorable Supreme Court. It is specifically stated that we extend the interim bail order to the petitioner till the next date of hearing, and the Honorable Supreme Court is aware that the matter is to be listed today, and it has been listed. So
that report not yet received. So far, the submission advancement Lawrence senior that the present petitioner only convicted on 120B, but your lordship may candidate page 52.
No, we then we will write that in spite of the order passed by this court on such and such date, you have not produced any report that the petitioner has misutilized the liberty.
On the last occasion, I had filed my appearance before the police station every Monday as directed. Even on last Monday, I have appeared. आठ बार रे मैं appear करी.
Yes, any Mr. Rotho? Anything further you have reported? No, my lord. You have not reported. Is it any within your knowledge that after being released on bail by the order of this court on 9/10/23, it has been
I have threatened. Therefore, I have approached the witness protection scale. First, I approached the Salon Court. Then I went to the witness protection cell. Then I was being granted with protection.
No, we are not on that. We are asking a specific query about any report produced before, because no written report is coming.
No report
either. So neither the state producing nor you are producing. And there was a specific direction issued by this court. It is not that when the Honorable Supreme Court said to give a relook of the matter, as Mr. Panda rightly pointed out, that this court felt it necessary to take into account the conduct of the appellant during all these periods when the liberty, and so we'll say that you have not produced any report to that effect. State has not, state nor you both are not produced.
Half the time, my lord, he was in hospital.
I cannot produce any report, and any other state has not.
All right, then now come to, let us, is it a case what Mr. Panda said that his involvement is that of criminal conspiracy? He was not actually present at the scene of occurrence when the crime was committed, but he was inside the jail. Is it the finding of the London trial court?
Page 52.
Page 52 of
The
the trial
on
court.
conspiracy was 302. He has been convicted. Page 52. The conspirator is designed more than the perpetrator of crime.
302/120B by 34.
That's right, obviously.
What is the no? Whether your eyewitnesses have stated, is there any eyewitness to the occurrence?
Yes.
So who are the eyewitnesses?
There are 6 or 7 eyewitnesses.
Have they stated about the presence, Mr. Rotha?
Yes.
The petitioner was present at the
No. Not present.
So not present at this.
Not present. That's correct.
And he was in jail at that point of time because he was not granted bail.
Yes, sir.
So in jail, a person, and allegation is that he is involved in criminal conspiracy. That was accepted. That is to be adjudicated.
What is the date of incident?
6/12/2015.
6/12/2015. Just see page 47.
Yes.
In the instant case.
Internal page.
Judgment. In the instant case, PW20.
In the instant case,
In the instant case, PW20 has stated that in the year 2013, FIR was lost, and so. Luckily was escaped. No. Read. Around Tulia, Jena, and Chogala Malik, around 15 to 20 days prior to 6/12/2015, the date of incident.
He had received a phone call threatening him to kill, for which he had lodged an FIR at Mangala PS.
Yes.
And on the next day, posters were sticked on the wall of his house at village Moindipur, where it was written that he would be killed. ସେଟା ପରା ଆଜ୍ଞା PW15 ର ଏଭିଡେନ୍ସ ର ବାହାରିଛି, ମୋର କିଛି କନେକ୍ସନ ନାହିଁ। ଆଉ 2 ଜଣ ଆଜ୍ଞା they failed trial and they have been acquitted. A judgment where PW 15 Ranjan Kumar Malik was examined. He was the IIC Biridi PS.
Okay. So, Mr.
No, what you see, it says that that luckily escaped. In that case, police arrested Tulia and Chogala.
That is
15 for 20 days prior to the incident. Therefore, you are in custody.
Nah. I was in custody in connection with another case registered against me, not in this case. Not at the instance of this. This is an erroneous observation.
But you are in custody.
I was in custody, yes. From the very beginning, I have taken the plea.
That I was not disputing that when the crime was committed, he was in custody. So, if somebody is in custody, then what are the materials according to the plan and prior for this criminal conspiracy?
Para 10, your lordship may see of the judgment.
Para 10 years. With regard to the offense under 120B, IPC, categorical declares that the accused person is conspired with Tulia. As per the instruction, they has the plan and committed the murder of the deceased, and the settled law that the criminal conspiracy can be proved by circumstantial evidence. The conspiracy of criminal.
Your lordship may look at the next page, internal page 43, running page 55. What the court writes is, conspirators invariably deliberate plan and act in secret over a period of time. It is not necessary that each one of them must have actively participated in the commission of the offense or was involved in it from start to finish. What is important is that they were involved in the conspiracy, or in other words, there is a combination by agreement which may be express or implied and in part implied. Conspiracy arises and offense is committed. As soon as the agreement is made, offense continues to be committed so long as the combination persists. That is, until the agreement is terminated by completion of its performance or by abandonment or frustration. The court has to be satisfied that there is a reasonable ground to believe
theories.
Yes, Mr.
What is the evidence?
I think is at page 47.
Meeting of mind
Page
preceding the crime.
Yes, sir.
Yes.
Page 47. In the instant case, PW20 has stated that in the year 2013, he has lost an affair regarding bombardment at his liquor shop at Brahmajharilo by unknown persons, and luckily he was escaped. And in that case, the police arrested accused Tulia, and he is arrested for bombing my shop. Chagala, around 15-20 days prior to it, he had received phone call threatening him to kill, for which he has lost affairs in all of stations on the next day. The poster was stick on the wall house and village Mehendipur, where it was written that he will kill PW20. Kill PW20 further stated that a successful bidder, he is a successful business rival, successful bidder in the department. Irrigation RD and block civil works, accused Tulia Jena kept grudge upon him and the deceased since 2013. And he had doing all these activities against him, and the accused Tulia Niganda had hired some persons to commit murder of his younger brother. Prosecution has also proved the copy of the FIR lodged against the accused Tulia at the Mangalabag and Biridi police station, Cuttack Sadar, prior to lodging of this case, which clearly show that there was a previous rivalry with the deceased by the accused Tulia. That apart, the evidence of PW3 shows that he had seen the accused persons in the house of accused Tulia, and also PW14 has also clearly deposed that he has seen the accused persons doing the house and Tulia, Basandra, so and so on. Accordingly, the accused Tulia, for 1 month of the death of the deceased, poster were sticks around the informant house and Mehendipur, threatening him to kill in connivance with Samir Patnaik, and have done these things in connections with the irrigations and R&B tender from the intentions that accused Tulia Jena.
So, Mr. Ratha, if we rightly followed your argument, you said that the conviction that has been, there are materials on record. Ultimately, it is to be adjudicated in the while final adjudication, whether this conviction is to be upheld or set aside. That's one aspect. but the criminal antecedents are there, and
302 cases.
Huh?
302 cases out of that 23. And another one more aspect. During the trial stage, this Honorable Court granted bail. We challenged it in before the Honorable Apex Court. Honorable Apex Court, considering the antecedent alone, has set aside, and that order has given by.
It's all right. With that, we have seen.
Yes. So, so presumption of innocence.
So,
the role played in the PW 14 statement mechanism. PW 14. Let's call that.
No, the thing is that if we state anything on the merit of the case while adjudicating the bail application, that will have its impact on the final adjudication. We are not touching it just by the way, since it is coming before us for the first time. We are just seeing that what are the materials. We are not commenting on anything
in view of the
on the appreciation of the evidence.
So my argument to come on, sir, there are enough evidence which has been considered by the learned trial court. It's not the case that even though it's bound to be circumstantial because it's 120. There are circumstances which has been appreciated against the.
Is it correct that what Mr. Panda has submitted, that in none of the case he has been found guilty, and in all the cases he has been on bail? You have not stated anything in your. You have gone to Delhi because no opportunity was given. Now the opportunity has been given. What is your say?
Well, cases have given that because he is once he is out. Kindly see, my lord, that number is of 1993.
No, you.
They are avoiding the court process by this, and none of these has been completed.
No, we want an answer from you, my lord. Mr. Panda has stated specifically in the your that rejoinder to your objection that the petitioner has not been convicted in any case, and he is on bail in all the cases. You are not controverting it because you are not bringing anything on record.
Right.
And
the only thing
we are asking, you will record also that you may tomorrow go that and say that opportunity has not been provided.
No, I'm not saying that. I'm not. Well, this 302 cases is not in bail as far as my instruction is concerned in 1993.
1993 का जगतसिंहपुर
जगतसिंहपुर
जेल रे अछि गला सप्ताह या डेट थिला लास्ट वीक द इन्फॉर्मेंट केम एंड वाज एग्जामिन्ड इन चीफ ये गोटे कहउछन या मिछ कथा गोटे ढाई कहउछन
Yes, Mr.
your lordship kindly bear with me for one moment.
Paragraph 3 of the objection which we have given a list of cases where he has been showing antecedents. We have also given a list of cases where he is wanted. Lordship sees that.
No. We have on that point that in any case he has been found guilty. That is
I think the state will say.
Because that is the specific reason.
These are the 302 cases where he is wanted.
Oh.
And one aspect, just I will add, I will not take your lordship time.
Yeah.
But that submission which was made by Mr. Ratna, the bail order was cancelled while the bail was granted during trial. During trial, his bail was refused. This Honorable Court granted bail. It went up to the Supreme Court. There, the Honorable Supreme Court held that because of the antecedents, it cannot be granted. So, my submission is, Your Lordship, subject to Your Lordship's consideration, that even at that stage, the Honorable Apex Court felt that in view of the antecedents, he cannot be granted and cancelled the bail. Now, after conviction, after what my Lordship has placed, whatever materials for Your Lordships to consider, can there be a better case or a better situation than that?
That we will decide.
Your Lordship may decide.
All right. Yes, that is gone so far as this case is.
Lord, can I reply?
Yes.
Lord, I am only.
Yes.
Your Lordship has been drawn to this observations which the trial court has recorded at page 47, my lords.
Yes.
Now, the very same PW20 at paragraph 24 admits, I have filed certified copy of case number 94 of 2015 under Biredi PS. It was an incident relating to pasting of threatening posters. It is a fact that Nigamananda Jena was not an accused in that case, and Samir Patnaik and Subhrakanta Das are the accused persons. IO of this case has also seized Xerox copy of the threatening posters from the IO of B.Redi PS. If this is the evidence, how can the trial judge write this in his judgment?
Yes, all right. Now the next case is the other case,
About the 2013 case, what he has said, Your Lordship,
758, who is
758, we have filed an IA 506 of 2025 for 506 of 2025
yeah,
for cancellation of bail.
506. No, it is to be decided by yourself. Where is the cancellation of bail?
Because he is in between he is implicated in another case.
Acha. Oh, so that is not there for Mr. Panda's case.
No.
After being released on bail, that 506 and his earlier bail application in which bail was granted.
Now
that is what is the number? Bail was granted in
IA 2097.
2097.
2020.
There also you have filed the objection also.
Common objection filed.
Common objection you have filed.
Indicating the implication of all the accused persons.
Yeah, यानर भी अच्छी है ये.
समते 17 18 20.
अच्छा.
ଏଟା କିଛି ଆଜ୍ଞା ରେକର୍ଡ ପଢୁନାହାନ୍ତି ଏଭିଡେନ୍ସ ପଢୁନାହାନ୍ତି ଆଇର ଏଭିଡେନ୍ସ ମୁଁ ପ୍ଲେସ୍ କରୁଛି
758 758 ଟା ଟିକେ ଦେଖିଲେ 758 ରେ ଯୋଉ ମ୍ୟାଟର ଟା ଅନରେବଲ ସୁପ୍ରିମ କୋର୍ଟ କୁ ଆସିଲା ସେଟା ତାକୁ ବେଲ ଦିଆ ହେଇଥିଲା ଆଇ ନମ୍ବର
ସେମ୍ ଅର୍ଡର 2097 ଗୋଟାଏ ତ
ହଁ ହଁ ଦଶ 2097 ଏଇଥିରେ ବୋଲେ. Yes, who is the counsel here?
Mr. Y. Das.
Yes, Mr. Das, what do you say? CRL number 758 of 20.
My learned friend has stated most of the facts, my lord.
Yes.
I'm just adding. And my lord, I have one submission to make, my lord.
Yes.
Lord, we don't mind. My lord need not be so hurried to dispose on the map today, my lord. My lord can also extend the bail and hear it tomorrow if my lord so pleases. Because my lord is cessation of the matter, my lord.
Yeah.
So that not as if it will be a violation of the High Supreme Court order. I'm only stating, my lord, that it's 4:30. My lord can hear it tomorrow. I'll be before my lords tomorrow. I'm coming by 7 o'clock flight.
No. This is the limited thing. He said that opportunity was not given, and written objection was now he has filed the written objection also.
Yes.
Objection
My lord,
has been-
again, my lord, basically antecedents. And the other one that he's talking about is it was a skirmish between me and my co-accused, my co-convict. And my lord, I've been granted bail by this honorable court already, my lord. In that other matter. Other ones, my lord, there is nowhere I've been convicted.
But in addition to that, Mr. Das,
yes, my lord,
he has pointed out, Mr. That after being released on bail,
that is the matter. That is the matter, my lord. Where I was an employee of the person who alleged conspirator with me, my lord. He is the one I had some skirmish, my lord. He filed an FIR. And it was a skirmish between the co-convicts, and I have been granted bail by a single judge of this honorable court, my lord.
That is under 385 of two.
Yes, my lord.
That is Lakshmi Sagar PS case number.
Yes.
38 dated 19720.
Yes.
He wanted me to finance the costs of the appeal, which I refused.
Magistrate. What about this is only sole objection?
Yes.
That's all. Same.
That's the sole objection.
He has participated.
Eyewitnesses have implicated.
Yes. All the eyewitnesses.
Yes. Implicated, my lord, may I kindly see the FIR. The substratum of the FIR, my lord, may I just place, my lord. My lord, this is the informant who files this FIR. My lord, I have translated into English, my lord. I, Rasbihari Das, aged about 41 years, son of late so-and-so of Thoria Sahi, PS number so-and-so. Today afternoon at 4:30, Rohit, who is my supervisor under my construction shop room at Brahmana Jorilo market, called me on mobile and said that my younger brother, Vinod Bihari Das Kuttu, was standing in front of the shop under construction and watching the work of the going on in on a motorcycle came having liquor from the nearby shops, suddenly came to my brother and took out short guns and fired them while shouting so and so, my lord, competing with our Tulia Bhai in his business. This is, my lord, where the conspiracy theory comes in, my lord. And we will kill him today and we shall kill you. Tulia Bhai, so and so, of so and so place, Biridi, district so and my wife, Jinmoy Jena, who is also involved personally in her.
So, Das, your implication is based on eyewitness account also.
Yes, my lord. The eyewitnesses that are there, my lord, they have nothing has been stated about eyewitness who have seen them.
We are not going to touch anything as we have stated. We are not going to pass any observation whether the evidence is acceptable or not, because that would have some kind of effect.
I bow down to that, my lord. Yes. My submission is this much, my lord. My lord, there are the eyewitnesses who have indicated, my lord. The eyewitnesses are PW 1, 2, 3, 5 is not eyewitness, 6, 7, 11, and 12.
Yes.
One says, my lord, PW 1 says 2 persons came on the spot, 1 person remained on the road on the bike, another person went to the liquor shop, and then near the deceased shot the deceased by gun. 1 person. The statement PW lacks corroboration from eyewitnesses 2, 6, 7, and 11, my lord. I have given a note, my lord.
Okay.
And my lord, next page, my lord, PW 1 and 5 are eyewitness state that 1 person shot the deceased, whereas PW eyewitnesses 2, 6, 7, 11, and 12 depose that 2 persons shot the deceased. But PW 5 and 6, 1 person shot the deceased. And 3, my lord, 3 persons shot the deceased. Which is the third person, we don't know. Then PW 2, 6, 7, 11, and 12 depose that 2 persons shot the deceased.
Sir, your objection as well as in the state objection, you have covered both the.
Yes, separately my objection.
This aspect, my lord, has not been covered at all. But regarding regarding this sort of a, and my lord, interestingly, the brother comes and tells my people were there who have seen the.
We are not going to enter into. We are just saying that have you raised your objection as per the direction of the Honorable Supreme Court in that objection in respect of all the accused or only in respect of Tulia? He says that in respect
all
what he wanted to know.
Yes.
All right. So we are reserving the order in both the cases.
I have got only one statement to make. The observations of the trial court, so far as my appellant is concerned, at page 47 and 48, both these observations, Millards, they are beyond the evidence on record.
Okay.
So far as the allegations, Millards, are concerned, Millards, about FIRs, Millards, if your lordship will look at the judgment itself, there is no such FIR has been exhibited or proved at the time of trial. ସେ ଯୋଉ କହୁଛି ଜଜମେଣ୍ଟରେ କୋର୍ଟ ଯୋଉ କହୁଛନ୍ତି that copy of FIR lodged against accused Pulia at Mangalabag, Biridi and Sadar PS Cuttack prior to lodging of the case clearly shows there was previous rivalry with deceased by the accused Pulia. No such FIR is there on that. That your lordship can ascertain only from the list of exhibits in the judgment.
All right.
And then paragraphs 42, 43 and 44 of the IO Millers, PW21. He admits also.
First, CRLA number 423 of
I have one submission to make subject to pleasure of my lord.
CRLA number 423 of 2023, IN number 926 of 2023. 926 as is an application for bail of appellant Tulia alias
Nigamananda Jain.
Nigamananda Jena. The appellant was directed to be released on bail by order dated 9/10/2023. It appears that the informant approached the Honorable Supreme Court against the aforesaid order and বলা গেল সেই অর্ডারটা যেটা ক্যান্সেল করা গেল নাই না সেটা
Page 271.
271.
না না এইটাই বিন যেটা
Annexes flag B. Flag C, Annexure B, order dated 7th of May 2021.
Actually, the Honorable Supreme Court had order dated 7/5/2024. ठीक तो? In SLP number, SLP criminal number 457 of 2024.
Along with SLP.
Along with
now
SLP 459 of 2024 and 458 of 2024 has been pleased to set aside the said order however directed that the petitioner shall remain on bail till 15/5/2024, on which date the court may pass appropriate order in the matter of its continuance or otherwise pending disposal of the interlocutory application for suspension of sentence. Stop. The matter was brought to the notice of the matter was placed before this bench on 1/12/2025 and we passed taking into account the order of the Honorable Supreme Court. We passed the order directing the petitioner to surrender, the appellant to surrender by 6/12/2025 and with a further direction to produce the surrender certificate and fix the case for consideration of the bail application to today. The Mr. Devasis Pandal and counsel for the petitioner submits that against the order passed by this court on 1/12/2025, the appellant approached the Honorable Supreme Court in SLP criminal number 1966 666 na 06 tinta chha 6 of 2025 and he has produced the copy of the order which shows that the Honorable Supreme Court, after considering the factual matrix and that the bail application will be taken off today, extended the interim bail order granted to the petitioner till the next date of hearing before this court, that is today. Accordingly, the specialty petitions were disposed of. Stop. Heard Mr. Devasis Pandal and counsel for the appellant, Mr. Aurobindo Mohanty, additional standing counsel for the state, Mr. Gauri Mohan Ratha, land counsel for the informant,
Led by Mr. Ramakant.
and Mr. Ramakant Mohanty, land senior advocate for the informant, informant. It appears that the state has filed the objection to the bail application. ଆପଣଙ୍କର objection ଟା କୁଆଡେ ଗଲା? ଆଚ୍ଛା. So also the informant has filed subjection which are on record, and copy of such objection have been served on the learned counsel for the appellant. Who has filed? The learned counsel for the appellant has also filed a reply affidavit to the objection filed by the state as well as the informant, which are also on record, and the copies of such reply affidavits have been served on the learned counsel for the state as well as on the learned counsel for the informant. Stop. Order is reserved. The interim bail order granted by the Honorable Supreme Court as per order dated order dated
5/12/2025. December 20.
Order dated 5/12/2025 is extended till the delivery of the order. Stop. Same order karibe Yashobhan Das land senior, that is in CRL number 758 of 2023. Hello. Au तादिर भी देख बेल देखिए नहीं लिखिए ले एसएलपी नंबर टा एसएलपी नंबर टा होची तादिरे अलगा है जेता तोड़े लिखाई जोटा दिरीटा एसएलपी है एसएलपी नंबर टा के रेउची the order my lord is a noun matter 1966 1966 number আমি টাকি দুই নোট কালে বলবা লাগো
19660 19660
0 yes my lord
19660 উপরে আছে
that's the leader
ସବୁ ଉପରେ ଅଛି title is same ଅଛି no problem but the last one top last one it got repeated last ସବୁ ଯୋଉ
ଏଇଟା ତ ସେଇଟା ନା ଏଇ ଯୋଉ
ଏଇଟା ତିନିଟା ଫାଇଲ ହେଇଥିଲା
अगर जो कैंसिल ହେଲା ଆଗର କୋଟା ଏସଏଲପି ନମ୍ବରଟା କୋଟା
you don't know the three matters
ଠିକ ଅଛି ତାହେଲେ ଏଇଟା ଏଇଟା କରିଦିଅନ୍ତୁ
ରହୁଛି
ଆଜି ଯୋଉ ଏକ୍ସଟେନସନ ଟା ହେଇଛି
19
ଏଟା ହଉଛି ଏସଏଲପି କ୍ରିମିନାଲ ନମ୍ବର 19666
double six zero ଗୋଟେ triple six ନା ମୋର ସେଇଟା 660
ଫାର୍ଷ୍ଟ ହଉଛି 660
ହାଇ
ଆଉ ସେକେଣ୍ଡ ହଉଛି
no
666 666 and 660 is
यारटा सीधा हो
बिहारटा होची 660 एटा जोटा आकरटा होची 666 ओके बाकी सब मान रहइबो दिस इज एक्सटेंडेड अच्छा ସେଇଠି ଖାଲି ଗୋଟେ line add କରିଦେବେ. An interim application has been filed by the Land and Council for the state. That IN number সেটা দেখিলে 506 5063 500 cancellation. That is in 758.
The 506 of 2020.
An interim application has been filed by the who has filed this? State has been filed for cancellation of bail of the appellant, mainly on the ground that the appellant has deliberately misused the liberty granted by this court by involving in the commission of offense under section 385 of IPC in Lakshmi Sagar PS case number 238 dated 19/7/2020. 19/4 19/7 election.
Paragraph 6 page 7 है paragraph top 238 dated 94 paragraph 7 সেটা
19/4 টা ঠিক তো 19/4 FIR টা annexure করছেন annexure C 19/4/2024 and that the petitioner that the appellant has also flouted the order directing him to appear before the concerned police on every Tuesday. You have not filed any objection.
We have filed an objection, but as regards this, my lord, we have been appearing and I have got the copies also of the.
No, have you to this IN number 506 of 25?
506, my lord, I have not given a response.
The Yashovan Das Land Council for the senior advocate appearing for the sworn to submit that he has not filed any objection to the interim application, but he has instruction that the appellant is regularly appearing before the concerned police on every Tuesday. That is your instruction.
That's fine. And my lord, I have been granted bail by this honorable court on 21/6/2024.
That we'll see that. See what khali for ye would change over date would I think Mr. Devasis Pandankar lekhi that he has produced some documents to show that the petitioner or the appellant was appearing before the
IIC Sadar
IIC of
Sadar PS
Sadar Police Station Cutter.
Every Monday direct.
These are taken on the. It has a faster lekhi level. Tulia alias Negama.
I have only one submission to make, my lord.
Till the delivery of orders. So now you got two orders so far as TRL 423 और 758 এটা হলো order reserve হলো and bail extended till the delivery of orders, right? বাকি এইটাକୁ କୁହାଗଲା ଆଉ ବାକି ତ separate ନେଇଥିବେ ଆଉ 141
is on inside custody
141 ଟା in custody ହେଲା
629 not
ଆଉ ଏଇ ଯୋଉ 629 ଟା ପହର ଦିନ ଆସିବ ହେଲା.
May I just have
1141 सरेंडर कर देगी पक्की दूं ताकि सब ने आउट डेट कर दो है ना. He is in custody, his bail application will be considered, but this 629 will be considered day after.
Yeah,
that is on 12th of December.
Madam, may I just submit something?
Any objection was filed in pursuant to direction of the Honorable Apex Court, copy was not sought. So let them sought the copy. What is their objection?
That's the reason, my lord, the matter was adjourned earlier, my lord. So, because they are not filed, that is the reason the court.
I will not contest.
My lord Justice S.K. Panigrai and my lord Justice Satpathy were sitting. They didn't produce that.
I am not contesting. I'm not contesting.
My lord, I just want to indicate one thing. No, my lord, I want to submit one thing.
Can I make one submission?
Yes, Mr. Das, what do you say?
My lord, I only want to say one thing, my lord. If my lord is not believing the one part of the prosecution story, my lord, as regard I am concerned, I am supposed to be a person who is in his employment, and I am the person who is supposed to be the person who has been directed to kill. That is the idea, fundamentally.
So Das will not touch on the merit of the case. Be rest
No,
assured.
that's all right, my lord. I'm only showing glaring things, my lord. Only glaring things, my lord. I'm only
Whatever minimum is necessary for consideration of pay.
That will be.
Yes, that's right. No, I was just insisting my lord was I'm going to be for my lord tomorrow. I was just stating, my lord, if I can be permitted. I'll go tomorrow.
I'll file a written.
Can I file a written submission, my lord? By tomorrow.
Order to ଆମେ reserve କଲୁ ଆପଣ ତ ଭିତରୁ ଯିବେନି ଯାହା ଫାଇଲ କରିବା କଥା କରନ୍ତୁ. Because this matter is coming day after tomorrow, but this matter will not come, but only that other matter that Mr.
My lord, I have some difficulty. My briefing counsel, my lord, unfortunately, his son is very unwell. He has come to Delhi for a surgery, immediate surgery.
I'll be written note, but we are likely we have said that you will not be taken into custody. That's all.
The order may kindly be upheld.
Yes. Okay.